Going to call the BZA meeting to order here this morning, and there's a couple of housekeeping details.
Can you turn it up just a touch, or somebody be quiet? Can you turn it up just a touch?
You can't hear me?
No, I can't, thank you.
Okay. So there's a clipboard over on the side table. If you haven't signed up for this case, if you haven't signed up today, make sure that you sign up so that you get correspondence on this case going forward. I'd ask that all cell phones be silenced. That reminds me. And please, at the end of the day, leave by the same door that you came in, so at the end of the day, they are not trying to locate you in a broom closet somewhere. So with that, Mr. Dixon, would you go ahead and introduce the file?
All right, case 6530, an appeal of a decision made by the Bureau of Resource Management regarding a decision for the Forest Conservation Plan. The site is located at 2239 Bachman Valley Road, Manchester, Maryland, on property zone A, Agricultural District and Election District 6, by John Trimloney and 10 other applicants. Code of Public Local Laws and Ordinances, Section 150.14 and 158.133B1A. A site visit is tentatively scheduled for January 15, 2025 at approximately 9:45 a.m. In the file of this matter, we have the following documents. A letter from the Maryland General Assembly to the members of the Board of Zoning Appeals. It's signed by Delegate Chris Tomlinson, Delegate April Rose, Delegate Christopher Eric Boucher, and Senator Justin Reedy. And it ends with, it is essential to point out that the property owned by the church consists of 25.45 acres, and as stated in the written findings, the proposed development of the site is approximately 12.32 acres. With less than half of the property being developed, we do not understand how it would be impossible for only 4 trees to be preserved and how alternative options were exhausted. We stand with the communities of Bachman's Valley, Ebbvale, and Melrose in opposition of this variance and kindly request that you sustain the appeal. There is a notice of public hearing on January 29th, 2025 in the Carroll County Times. And then there's this appeal from the Bureau of Resource Management. They approved a forest conservation plan associated with site development plan. There is a November 25th, 2024 letter from Christopher Hahn to DRS and Associates in reference to application for variance. After a thorough review, a public hearing on November 8th, 2024, and other considerations, the request for variance is granted. A copy of the written findings is attached to this correspondence. And then I see another sheet without a date. Let's see, it's signed by Christopher Hahn, dated November 25th, 2024. It ends with, as with all variance applications, the application as well as supporting information such as the Forest Conservation Plan were reviewed for substance and completeness. It has been determined that sufficient information has been presented to determine that the applicant has met the intent and requirements of Chapter 150. The request for variance is therefore approved. There's an application for a variance to Carroll County Code, Chapter 150, Forest Conservation. It looks like the applicant is Daniel Staley. Looks like the date is October 11th, 2022. There's another November 25th, 2024 letter from Christopher Hahn. Looks like a similar letter. Also dated November 25th, 2024. Another application for variance to Carroll County Code, Chapter 150, Forest Conservation. Maybe there's some duplicates in here. There's a December 10th, 2024 letter from G. Macy Nelson to Joe Vance. All right, there are a number of response memos to Joe Vance's request to various state and local agencies. There is a response from J.P. Smith Jr., Program Manager, Ag Land Preservation Program. His comment, this property is not in ag preservation. I have no comments at this time. Hearing notice was posted October 1st, 2024 by Scott Robinson, zoning inspector. There was a notice of public hearing September 30th, 2024. This is a de novo hearing from the Bureau of Resource Management decision. And I would ask that this file be entered into evidence.
Do I have a motion to enter the file into evidence?
So moved.
Do I have a second?
Second?
All those in favor, aye.
Aye.
All opposed, no. We will move the file into evidence. Before we get started, I'm going to attempt to explain what our procedures are here at the Board of Zoning Appeals. I promise you at the end of the day, you'll understand them. The appellant will have, I see two lawyers here seated before us. The appellant will have the opportunity to make opening statement, and I see the county attorney is, one of the county attorneys is here. She will also have the opportunity to make opening comments. And then I'm assuming that there will be witnesses called by the appellant, and at the end of each witness's testimony, anyone from the audience or, wait a minute, let's put an asterisk next to that, almost everyone from the audience can ask questions of that testimony. The board will have the opportunity to do the same thing. Then, when the appellant has finished calling all of their witnesses, the county attorney will call her witnesses. People in the audience, and again, I'm going to put an asterisk, all people in the audience can ask questions of that testimony, and only that testimony. The board will have the same opportunity. When that is all concluded, then anyone, again, I'm going to explain the asterisk, anyone can ask or give their own testimony about this case today. What's the asterisk for? The asterisk is anybody that is represented by legal counsel here today has to give their questions or their testimony through the legal counsel. So can I just ask for anyone that is represented by legal counsel here today, could you please stand? So you all are,
This is what they use.
so,
We understand the chair's rule and we'll respect it.
okay, I just wanted to visually see. So everyone except the two gentlemen back there are represented by legal counsel, is that correct?
Well, there's people right here, too.
We'll adhere to that rule.
Oh, I'm sorry, I didn't see, okay, so I just want to get that clear because we've had a lot of confusion in past cases with people asking questions when in fact they should have been done through their legal counsel. So I wanted to get that straight from the get-go here today,
We got it.
okay?
Thank you.
Now, if you plan on testifying today, please stand and take the oath. So if you're going to testify, and if, Mr. Nelson, if you have any of your people,
So anyone who, anyone who wants to stand up, take it. Doesn't mean you have to testify. I'm sorry.
okay, so you all will be called as witnesses, or possibly called as witnesses.
Possibly called as witnesses.
Okay, thank you. So, wait a minute, stand up, I'm sorry. So please raise your right hand so you can take the oath. You guys on staff are not, okay. Do you swear or affirm under the penalties of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? I do. Very good, you can be seated. Now, before you speak, I would ask that you would state your name, your address, and occupation, and spell for the record your last name. So, Mr. Nelson.
Thank you, Mr. Chairman. Alex Volto will make the opening statement on behalf of the
Yeah, and
appellant.
you can remain seated so that we can get your every last word recorded.
Thank you. Alex Volto will make the opening statement on behalf of our clients, the appellants.
Is your microphone off?
Says
Hear 'em, but
it's on, I think.
Okay, very good.
Would you also like me to?
Yes, yes.
So Alex Votaw from the Law Office of G. Macy Nelson. Our address is 600 Washington Avenue, Suite 202, Towson, Maryland, and we're attorneys.
Okay, and spell that for the record, please?
Yes, absolutely. Last name is Votaw, V like Virginia, O, T like Tom, A-W.
Very good. Thank you. And you can proceed.
Thank you so much. Thank you, Board, for being here this morning, and good morning. We're here today to discuss a forest conservation plan and an associated application to remove over half of the specimen trees on the property described previously by Mr. Dixon with an address of 2239 Bachman's Valley Road. This is all in an association with a proposed plan to develop a very large religious establishment with maximum capacity in a relatively rural area. The reason the applicants or the appellants appealed this plan is simply because the plan and the variance requests do not meet the requirements of the law. So what is the law that we're talking about? Today we're talking about the Forest Conservation Act, which is codified in the county's ordinance at Chapter 150. And the Maryland Supreme Court recently, in 2022, described the purpose of the Forest Conservation Act. And it's to create a system that balances interests between property owners and their need to develop their property and the well-being of neighboring property owners and generally the state in preserving important environmental resources like forest lands, wetlands, streams, and things of that nature. And the system that the Forest Conservation Act has created requires a property owner to proceed through the following process. First, the property owner is required to identify the environmental resources on its property. Again, important features for the Forest Conservation Act are woodlands and wetlands and things of those nature. That's done through the forest stand delineation. Then using that information, an applicant is required to design its site to preserve those resources as best as they can. And the law recognizes that some properties might be fully wooded. It might be impossible to preserve every single piece of woodland on a property, but it provides you with priorities for how to meet the requirements of the law. And it gives you a threshold amount of woodland you have to preserve on your site based on the size and the type of development that you are going to propose. So in this case, we have a threshold requirement for conservation of 15% of the net tract area. They have to preserve that amount of woodland on the site, and that can either be done through preserving existing woodland, or it can be done through planting additional forest, or it can be done through a combination of both of those. And there are other features that the Act requires an applicant to locate and preserve during this process, and that's something called specimen trees. These are large trees. They are very mature. They provide specific ecosystem roles. They're also better equipped to treat stormwater runoff and pollution from a site. They're important, and they've been prioritized by the Act for preservation. So what the Act requires, like I said, you identify these resources, you know where they are on your property, you figure out how much of it you have to preserve and what you have to preserve, and then you are supposed to design your development to meet those preservation requirements. Again, this is important because the state has recognized that existing woodland is the best way to treat stormwater runoff and pollution from development. It's the best way to protect neighboring property owners from flooding issues. It's the best way to preserve wetlands and stream systems from pollution that eventually make their way into the Chesapeake Bay. It's the best way to treat stormwater runoff and pollution from development, in addition to stormwater management issues throughout the state. So that is why it's really important for developers to preserve and make sure they're meeting the requirements of the law. Aside from the law just requires it, there's policy reasons why this is very important for not only neighboring property owners, but the state generally. So why are we here? What is the plan that we are discussing today? The plan in this case, we said there's 15% of the woodland they have to preserve. And in this case, they're planning to do that through preserving existing woodland on site and providing additional planting of forest on site to meet that 15% threshold. But the fundamental issue with the Forest Conservation Plan in this case is that the numbers provided, simply put, are a mess. They're inconsistent throughout the plan. They do not provide the county with a clear ability to determine whether or not the applicant has satisfied the requirements of the law. We're going to go through each of the ways that it does that, but here are the three major issues. The calculations for things like the net tract area, the threshold requirement, the amount of woodland being planted, the amount of woodland being preserved in an easement, all of those numbers are inconsistent throughout this plan. And I'll go through those with you today. They do not match up, they are not consistent, and therefore the county cannot possibly determine whether or not the applicant is meeting the requirements of the law through this plan because it's impossible to tell what the applicant is actually planning to do. For example, there are two different net tract areas provided in this plan. There's one that says it's roughly 12 acres, give or take a few decimal points, and there's another place in the plan on the same sheet that says the net tract area is 10 acres. These are inconsistent numbers, and they change the threshold requirement because it's 15% of the net tract area. If you're providing two different net tract areas, you can't possibly know what threshold requirement is required by the law in this case. So we'll go through those numbers. I will be honest, it's going to be a little confusing, and that's the point. This plan does not make sense. It is not consistent. It does not provide numbers that are accurate and consistent and allow the county to determine whether the plan meets the requirements of the law. And that is why the Department of Planning and Land Resources erred legally when they approved this plan. So that's just the plan itself. Now, I also want to talk about the forest conservation, or the specimen tree variance, the request to remove specimen trees which are trees that the law requires you to preserve. What we will show is that the application provided here does not meet the requirements set out in the ordinance in this county. The county requires an applicant to articulate specific findings and to provide specific evidence to demonstrate that they meet the criteria provided under section 150.14. The applicant did not do that here. So as a threshold matter, the department erred legally when they approved this application because the applicant failed to provide sufficient justification on which the department could even base their decision. There was no information provided. Now, respectfully, the department has stated they have a policy of allowing applicants to submit a short form for variance requests that are requesting to remove trees of a certain health. And in some instances, they exempt variance requests for trees that are considered dead. That is not permitted by the law. The zoning regulations, the chapter 150 in the ordinance supersedes any policy created by a department. The law enacted by the elected officials of this county and the state of this, state will supersede and have to supersede any internal policy. If the applicant did not provide sufficient justification, whether or not it's the county's policy to permit that, that does not allow them to violate the requirements of the law. That is what occurred here. Furthermore, what we will show is that even if the applicant did provide sufficient justification, it would not be possible to meet the requirements of the law. I'm not going to go through all of them. I don't want to take too much time, but I want to highlight some of the most important requirements for a variance from the Forest Conservation Act. One of the first requirements is that, I will read it directly. One moment. The applicant must describe the special conditions or exceptional circumstances peculiar to the property which would cause the undue hardship. The term special conditions or exceptional circumstances peculiar to the property is a legal term with legal meaning that that requires a certain level of proof to demonstrate compliance with that. And I'll go over what that is. Similarly, the term undue hardship in Maryland's land use case law has also been defined and has clear meaning. Now, Maryland's land use case law is broad. It includes acts like the critical area law. It also includes acts like zoning acts. In both critical area law and zoning case law, the term special conditions or exceptional circumstances peculiar to the property requires a showing of uniqueness. It requires that the applicant demonstrate that there is some feature specific to the property itself that is different from other properties in this area. That includes things like topography, size of the property, shape of the property, the existence and distribution of environmental resources on the property. Now, again, it's not sufficient to just have those things on the property or have it's not sufficient to just have that on the property. You must show that the extent and the type of features you have on your site are different from other properties in the area, and it impacts you differently to have to comply with this regulation differently than other properties. And what we're going to show you today is that there's nothing unique about this property. There are no special conditions or exceptional circumstances peculiar to this property. It's not unique in shape, it's not unique in size, it's not unique in topography, and the environmental resources that do exist on this property are not unique to this property. Many properties in this area have the same environmental resources, and many properties in this area are more burdened by environmental resources than this property. This is a 25-acre property on which a very small portion of the western side of that property is occupied by environmental resources. The vast majority of this property is flat, regular shape, large, and has no environmental resources on it whatsoever. So the property is not unique. That's a threshold inquiry. If you cannot find that the property is unique, the application for a variance must be denied. You do not need to look at any of the other criteria. But if you were to look at the other criteria, the next one would be whether the applicant experiences an undue hardship if they're required to preserve the 5 specimen trees that they're requesting to remove. And again, this has to be evidence that the need for the variance is not merely for the convenience of the applicant. You must show essentially that when you consider the entire property, the applicant would not be able to do its proposed development without a variance. In this case, as I said, this is a 25-acre property. At most, this development will take up 12 acres, and it has ample space to locate portions or all of this the proposed development on areas of the site that are not burdened or do not have specimen trees. These specimen trees are located on a very small portion of this property, and the applicant chose to locate this proposed development directly on top of them. The applicant could redesign the site. The applicant could shift the site to avoid the need to remove those trees. Furthermore, what we will prove today is that the applicant is providing a religious institution for a monastery. I don't want to butcher the name, so I'm not going to attempt it. But that monastery owns three parcels directly adjacent to this property. So when you consider the subject property and all of the property owned by the monastery, the applicant and the monastery have roughly 60 acres of unwooded land that they could provide or they could utilize to accommodate this proposed 12-acre at most development. They have plenty of space to develop this proposed development without the need to remove the specimen trees. So there's no undue hardship in this case. Another element that the case law talks about is a nexus. You have to prove not only that you have unique features, not only that you have an undue hardship, but it's that the unique features of your site have caused the need for the variance. So an example of this, let's say you have a property and the vast majority of that property is occupied by very steep slopes and erodible soils, and those areas cannot be developed. And so as a result, you have to locate any development on a small portion of your land because of those unique circumstances. That would be a sufficient nexus to demonstrate that you wouldn't be able to avoid the need for a variance, if not because of those unique features. That is not the case here. As I said, this property is 25 acres. They have a vast majority of that property which is unburdened by any unique features. They say that they need this development because they need this variance because the trees are in the way of what they want to do. That is not a sufficient nexus. The trees do not require the applicant to locate its proposed development where they're planning to locate it. Nothing about this property requires the applicant to locate the proposed development where it's proposing to locate it. The applicant could instead locate it on any of the other portions of the subject property or the property owned by the monastery and avoid the need for the variance entirely. So there's no nexus between any alleged unique feature and the need for this variance. Feeding into that, another requirement is that the need for the variance cannot arise from conditions or circumstances which are the result of the actions by the applicant. Now, again, case law has provided some insight into what this means. It's not just the current applicant. This also considers previous actions by previous owners on this property. That's what the case law says. So if I own a property and I develop it in a way that requires a variance to do additional development, I would not qualify for a variance. And what the case law says is it's not fair then if I'm allowed to sell my property, someone else is allowed to do that development, and then they can sell it right back to me and I can have what I wanted, which would otherwise be prohibited by this law. So what they say is it's a current applicant and any previous owner on the property. If they have made man-made structures, if they have developed the property in a way that has caused the need for this variance, that is an action that is the result of actions by the applicant, and therefore they cannot qualify for a variance. Now in this case, the director, when he approved the variance application, part of his justification was that the applicant wishes to locate its proposed development in close proximity to existing structures on the site. It's not clear from the record, because the applicant provided no justification for its variance, who built those structures. But regardless, the structures didn't grow there. They were built there by either this applicant or a previous owner. If the need for the variance is caused by the location of the existing buildings, that means the need for the variance is based on conditions or circumstances which are the result of actions by the applicant. That is not permitted by section 150.14. And on that basis as well, the application should be denied. And that's not to mention the fact, again, that The location of this proposed development, the size of this proposed development, is entirely a choice made by the applicant, not made by the requirements of the zoning ordinance or the requirements of the property itself. And the last thing I want to mention is that the applicant must demonstrate that a variance will not adversely affect water quality. Now, this is a particular requirement for the Forest Conservation Act as well as the Chesapeake, or the Critical Area Law. They both have this requirement. And in this case, again, the director respectfully, he concluded that the applicant satisfies this because they will have a stormwater management plan approved. That's not good enough in and of itself. You have to show that your stormwater management plan is good enough, reaches high enough standards to ensure that water quality will not be impacted. This proposal is providing an exorbitant amount of impervious surfaces. It's going to have pavement. It's going to have a lot of cars on it. That's going to result in stormwater that's more polluted than it was before. It's going to result in stormwater that moves at a higher velocity than it was before, causing more erosion to streams. And when you are asking for a variance, you have to meet this higher standard. If you were developing your property and you didn't need a variance, then sure, having a stormwater management, that's probably good enough. Having a stormwater management plan is probably good enough. But when you are asking for a variance from the Forest Conservation Act, you also have to prove that that stormwater management plan does not adversely affect water quality. That is not the standard that stormwater management plans usually have to comply with. They have to meet certain standards. They usually require that you don't impact to a certain amount or above a certain amount, or that you don't increase the amount of stormwater runoff from your site. But that does not guarantee that stormwater quality will be preserved. So you have to provide additional evidence when you are requesting a variance from the Forest Conservation Act. So that was a lot of information I threw at you. I'm gonna go over it again with our witnesses, but just to summarize, the Forest Conservation Plan in this case is deeply and fatally flawed. This should be a major concern for this board. The numbers do not match up. They provide various values in their calculations that are critical to approving a forest conservation plan. On that basis alone, the department's approval of this plan was legally erroneous, and we request that the board vacate that decision and remand to ensure the applicant provides the county with consistent and accurate values so the county can even determine whether they're meeting the requirements of the law. Secondly, the variance request was fatally flawed because the applicant provided no justification. The justification, they did a short form, and that was all they provided. Even though the application has the opportunity, gives the applicant an opportunity to provide additional information, they chose not to. So on that basis, we request that the board vacate the approval of that variance application and remand at the very least to require the applicant to provide that justification required by law. But we also believe that the evidence that we're going to present today demonstrates clearly that the applicant could not meet the variance requirement, and instead the board is well within its jurisdiction to reverse the decision and deny the application outright. So thank you so much for your time, and we look forward to presenting our evidence today.
Thank you.
Good morning, Mr. Chairman and Board. My name is Liz Moore. I am Assistant County Attorney, and I'm here today on behalf of the Department of Planning and Land Management of Carroll County. I appear before you today in regard to an appeal from the decision made by the Department of Planning and Land Management, specifically regarding a tree variance request. For a bit of background, again, the property is located at 2239 Bachman Valley Road, Manchester, Maryland, 21102, and is owned by Mr. McCoya. The property is zoned agricultural. The underlying variance request, numbered VFC 22012, was submitted by Mr. Staley of DRS and Associates on October 11th of 2022. The request was made on behalf of Mr. McCoya, the owner of the subject property. The subject property is approximately a 25.45 acre property, which is proposed to be developed as a religious establishment. The proposed development of the site is approximately 12.32 acres, including improvement to existing buildings, construction of a parking lot with 133 parking spaces, and other accessories related to the proposed use, including a septic system and stormwater management facilities. It should be noted that applicants were never made party to this action, nor the simultaneous circuit court action. Specifically, the variance request is to allow for the removal of 4 specimen trees located in close proximity to existing buildings. All 4 of the trees have been categorized as being in fair condition. Applicant asserted in the variance request that the trees are in conflict with the planned site improvements and that reasonable alternatives have been exhausted. Further, there is a 5th tree named specimen tree at issue, which has been noted to be dead and is at this point slated to be removed because it's a potential safety hazard, of which regular maintenance would be performed to remove it. No variance request is required for dead trees according to the county code. Mr. Bowman recommended the approval of the variance request to the director, Mr. Hine, and Mr. Hine granted the variance on or about October 13th of 2022. On October 18th of 2022, Mr. Bowman notified the Maryland Department of Natural Resources, their Forest Services Department, of the variance request, and on or about January 26th of 2023, Ms. Ann Gilbert, the Urban and Community Forestry Coordinator for the Department of Natural Resources, informed Mr. Bowman that upon her review of the submitted variance request, that the Carroll County Department of Land and Resource Management was within its authority to grant or not grant the variance at hand. Therefore, after 2 years had elapsed, on or about September 5th of 2024, the petitioners in today's matter filed a petition for judicial review in the Carroll County Circuit Court. Then, on or about September 25th, 20 days later, the same petitioners from the judicial review case filed the instant action with the Board of Zoning Appeals regarding the same exact tree variance request. Within that request, the petitioners allege that the Bureau erred legally when it approved the tree conservation plan and that it does not satisfy the requirements of Chapter 150 of the Carroll County Code. We'll get into the specifics later. Ms. Votal gave a very thorough assessment of their views, but we will get into that later. But nonetheless, the Department of Planning and Land Management respectfully requests that their determination be upheld and that you concur with the determination that a tree variance request was proper at the location of 2239 Backman Valley Road as it carefully and closely followed the Carroll County Code. Thank you, Mr. Chairman and Board, for your consideration this morning.
Thank you. And with that, you want to go ahead, Ms. Votal, would you want to call witnesses?
Yes, thank you. But before I do that, I have a few exhibits that I believe are technically part of the record, but I didn't hear it specifically mentioned previously, and I just wanted to make sure we all have the copies of the exhibits that we want to talk about. I was hoping to go through those and submit them into the record without a witness. I can do it with a witness, but I wanted to see what how the board would like me to proceed.
You can go ahead and submit those and give them to Mr. Dixon, and he will label them.
Okay, great. And I'll just, for ease of reference, I'll label them as appellant's exhibits 1 through whatever we get to. Okay, great. So the first exhibit I would like to provide is a copy of some of the provisions from the Forest Conservation Regulations. That's Chapter 150. I just thought it would be easier if we had those provisions all in front of us so we know what we're talking about today. So I have a copy for us. I have a copy for Ms. Moore.
I wanted to see if you had a copy from Ms. Moore.
Yes,
Very
of
good.
course. And then I have the copies for the board.
Thank you.
Applicants 1?
Yeah.
Okay, and we will accept that into evidence.
Okay, thank you. The second document I have is some of the sections in the Carroll County Forest Conservation Technical Manual. It just provides additional details about what a forest conservation plan requires. And I didn't include the whole thing. I think it's like 400 pages. So I just included the first couple of pages of the documents. So I have the cover sheet from the plan, and then I have those first couple sections. I didn't include the table of contents from the plan. I didn't feel like it was particularly helpful or necessary. So that's our second, what we've marked as appellants 2. Oh, sorry.
This is applicants 2. Okay, we will accept this into evidence also.
Thank you. The next document I have, which we will mark as appellants 3, is some of the sheets from the site development plan. So what I will mark as appellants 3 are some of the sheets from the site development plan. I'll proffer, my office obtained these from the county website. We were pointed to this website from members of the planning department. Again, the full planning sheet packet is 96 pages. I did not include all 96 pages. What I have included in this packet, and I have it hanging up here, is the cover sheet of the site development plan. I have what's titled Sheet 25 in the site development plan, and then I have about 6 sheets that make up the forest stand delineation and the forest conservation plan. So that's what I have here, and I have copies for all members of the board, and of course, Ms. Moore.
Ms. Moore, I didn't ask, did you, without objection?
No objections so far.
If there would be, you can interrupt.
I appreciate that.
Seriously?
I'm impressed at your age, you can read.
Thank you, Mr. Dixon. Oh, gosh.
Now, the,
And this is number 3?
yes, yes, sir.
And we will accept that into evidence.
Great. The next exhibit I have is the forest conservation application, the first page of which I believe was attached to the director's decision in the variance application, but there's also a second page, which is, I believe, the short form the director refers to in his opinion. And there's also 2 letters regarding the application as well. We obtained these documents from the county through a PIA request. So that's number 4. Here's it. And I added Bates numbering to the bottom so that we have page numbers we can refer to 1 through 4.
And we'll accept that into evidence also.
The next exhibit I have that I will mark as appellant's Exhibit 5 is a screenshot from sheet 80 of this plan where our office added highlights in red to the location of the specimen trees. I thought it would be helpful for the board to know which trees on this plan were specimen trees because it's not clearly delineated on the plan itself. And the second sheet of this is just a blow up of the table provided on that same sheet in the larger plan. While we added the red color, it is still, we believe, an accurate depiction of the plan that's already in evidence. So we would move that as Exhibit 5.
And we'll accept this as exhibit number 5.
The next exhibit that I will mark as appellant's Exhibit 6 is a memorandum in opposition that we filed with the department regarding the variance hearing that occurred later last year. I didn't hear it as part of the record described earlier, so we just want to make sure the record was accurate. So this is our memorandum we filed on behalf of our clients after that hearing in late 2024 regarding the variance for the specimen trees.
And you referred to the department, what department? Would be
The
planning?
Department of Planning and,
Okay. I just wanted to
Oh, that-
clarify
yes,
that.
thank you.
Okay.
and just maybe if I'm allowed. There you go.
And we will go ahead and accept that into evidence.
And the last document I have is the director's decision regarding the specimen tree variances dated November 25th, 2024. I believe it was part of the record, but if I may enter it just so we all have a copy and I know what exhibit to refer to during this case, if that's permitted. Okay, so I'm going to mark that as appellant's Exhibit 7.
And we will accept that into evidence also.
Great. So just to confirm, appellant's Exhibits 1 through 7 are admitted into the record, correct?
Yes.
Great, wonderful. So with that, if I may, I would like to call Ms. Ruth Grover as a witness.
Before we call
Yes,
witnesses, we're going to take
absolutely.
about a 5-minute break. okay?
Absolutely, thank you.
Call the BZA hearing back to order. And you want to go ahead and call your first witness?
Yes, sir, thank you. We'd like to call Ruth Grover, please.
Okay?
Make sure your microphone.
Okay, please state your name, address, occupation, and spell for the record your last name.
Good morning. My name's Ruth Grover. My address is 5727 Ridgeview Drive, Alexandria, Virginia, 22310. My occupation is a land planner. And what other information?
Well, spell for the record your last name.
Oh, it's Grover.
Okay, thank you.
GRO, what was it?
Grover.
Thank you. So, Ruth, could you please describe for us generally your educational and professional background?
I received a BA in 1978 in architectural studies, and in 1981 I got a master's in urban planning, and I entered the planning profession in 1984, and have worked for a number of different counties since then, continuously. For 41, so I have 41 years experience. That included most recently working for St. Mary's County in Maryland and Prince George's County in Maryland, combination of 17 years.
Thank you, Ms. Grover. And have you testified as an expert witness before?
Yes, I have.
Now, I'd like to show you what we have marked as Appellant's Exhibit 8. We will hand out to
Ms.
everyone.
Votaw, would you like her to be, would you want us to accept her as an expert witness here today?
Yes, sir. Expert in planning.
Okay. And based on the qualifications, we don't have anything in front of us, but based on what you said, we will accept her as an expert witness in that field
Wonderful. Thank you.
today.
So I'd like to show you what's marked as Exhibit 8, Appellant's Exhibit 8.
Yes.
Which I will hand out to everyone. Here we go. Thank you.
And we will accept that into evidence.
Thank you. So, Ruth, Ms. Grover, what is this document before you?
This is my resume.
And does it accurately reflect your experience as a professional planner?
Yes, except that most recently I've done some hourly work for Macy Nelson since my retirement from the Maryland National Capital Planning and Parks Commission in 2018.
Great, thank you. Now, I want to start our conversation and focus on the Forest Conservation Plan itself. Have you had the opportunity to review the Chapter 150, the applicable law for forest conservation plans in Carroll County?
Yes, I have.
Oh, I'm sorry, I'm gonna back up 1 second. I just wanna make sure. Was reviewing plans, development plans, part of your bread and butter as a planner?
Absolutely. It was pretty early on in my career where bosses discovered that I'm a people person, so I went more into development review than comprehensive planning. So I would review plans regularly for all these different entities that I've worked for.
And you were reviewing plans, were you tasked with determining whether those plans satisfy the requirements of the applicable law?
Yes, that is a large part of development review.
Okay, great. So now I'm gonna turn back to the Forest Conservation Plan. So you've reviewed the applicable law, correct?
Yes.
Have you had the opportunity to review portions of the technical manual, the Forest Conservation Technical Manual?
Yes, I have.
Okay, great. And have you had the opportunity to review the sheets that we've provided in Exhibit 3?
Yes, I have.
Okay. Now, did you find any issues with the forest conservation plan when you reviewed it?
Well, a lot of the numbers are off. It might even be on the same page where the size of the site or the size of the forested area are different in different locations.
Okay, and do you feel, do you recall a requirement that forest conservation plans accurately depict the 100-year floodplain on the property?
Yeah, so all the environmental features should be shown accurately.
And do you, in your review, did you find issues with how the plan describes and depicts the 100-year floodplain?
Yes.
What about forest clearing on the site?
In some locations, it says that no forest is being cleared.
And is that consistent throughout the application?
No.
Okay, so let's go through the numbers. So I'd like to turn our attention to what we have marked as Appellants 1, because I want to make sure we understand what the requirements of the law provide. So if we could direct our attention to Appellants 1, and we're going to go to page 7 to look at section 150.04. Now, section 150 point, I apologize, 150.05. 150.05 B describes what a forest conservation plan has to include. Is that correct?
Yes.
And could you please read for us section 150.05 B4?
It says, include a table that lists in square feet the net tract area, the total existing forest, area of forest conservation required, and the area of forest conservation that the applicant proposes to provide, including both on-site and off-site areas.
Okay, so it's true, is it not, that those numbers have to be consistent and accurate? Is that correct?
Yes.
And in your experience as a plan that has inconsistent numbers, is it appropriate to approve those types of plans?
No, because you can't judge conformance with the applicable requirements if the numbers aren't accurate.
And did you observe, I think you mentioned before, but did you observe inconsistencies or inaccuracies in the calculations on this plan?
Yes, I did.
Okay, well, let's talk about those. Chairperson and board members, I'd like to ask for some guidance. I have the large plan sheets up here. I've provided sticky notes just to direct our attention to areas that we're going to be talking about. I'm going to need to flip through these sheets. How would the board, is it okay if I stand up in the front and maybe point the microphones towards where I'm standing, and I'll just make sure I talk loudly?
Yes.
Okay, great. And just as we're reviewing this plan, I want to note how the sheets are labeled so we can make sure we're all on the same page. So sheet 1 is titled sheet 1 of, I think it says 96. It's on the bottom right-hand corner. It says what number sheet it is.
Is that in these plans?
Yes, sir. Yes, sir. The second page of this packet is titled sheet 25. The third through 6th sheets are the forest conservation plans. I think they're numbered 80 through 85, but there are two 80s labeled in this plan. We didn't number them. There's a sheet 80 of 95, and then the sheet after that is 80 of 96. That should be, I believe, the third and fourth sheets in this packet. So I know that's a little confusing. I'm going to make sure we're all on the same page, but I just want to preface that as we go through it so we make sure we know what we're talking about. So I'm going to move to the front here. I apologize to the audience that you can't see these, but you wouldn't be able to read the numbers from there anyway, I promise. So the law requires that the plan provide the net tract area. Is that correct?
Yes.
And does this forest conservation plan provide the net tract area?
The forest conservation plan gives two different figures. One is 12.32327, and the other is 10.3 12.13044.
All right, well, let's look and see where we find those. So I'd like to direct our attention to sheet 82 of 95 in this packet. And Ms. Grover, if you'd like to follow along, the plan is placed in front of you. That's marked appellants 3. So we should be on sheet 82 of 95. It's the third to last sheet in the packet. Uh, 82. Sheet 82. 95, okay, you're there?
Yeah.
Great. So do you see a box in the bottom middle of the page titled Forest Conservation Narrative?
Yes.
And do you see a green sticky note? I should have placed it in the same location for all of the exhibits.
Yes.
And do you see a sentence underneath which says church property?
Yes.
Can you please read that sentence for us?
Sure. Church property has no existing floodplain within the net tract area. Therefore, the 12.32327 acres limit of disturbance is the net tract area.
So this is saying the net tract area for this proposed development is roughly 12.3 acres. Is that correct?
Yes.
Okay, now let's turn our attention to sheet 85 of 96. That's the last page in the packet. Now, Ms. Grover, do you see 4 sticky notes on this sheet?
Yes, I do.
There's one sticky note on the top left in the forest conservation easement box. Do you see that?
Yes.
Do you see another sticky below that in the proposed forest planting analysis box?
Yes, I do.
There's another one top middle to the right-hand side in the forest conservation narrative box. Do you see that?
Yes.
And then there's a 4th one next to the forest conservation worksheet.
Uh-huh.
So that's the areas I'm going to focus on this sheet. So let's turn to the forest conservation narrative box. It's the top middle box. It's the top right-hand tab. Do you see that box?
Uh-huh.
And could you please read for us the second sentence under paragraph 2? It starts with, since there's no floodplain.
Yeah. Since there is no floodplain on the property, the net tract area would be 10.13044 acres.
Okay, and let's move briefly down to the forest conservation worksheet box where there's a sticky note. Can you please read the net tract area provided? That's it.
Here the net tract area is listed as 12.32327 acres.
So I think you said this before, but let's confirm. There's 2 different values for the net tract area provided in this plan. Is that correct?
Yes.
Is the net tract area is required to be shown by the applicable law, correct?
Yes.
And it has to be accurate and consistent, correct?
Of course, to be able to determine compliance with the requirements of the ordinance.
Well, that's a perfect segue. Let's talk about some of the requirements of the ordinance. There's a requirement that the applicant preserve a certain threshold of woodland on the site. Is that correct?
Yes.
Is that called, we'll just call that the conservation threshold? Does that sound familiar to
Yeah.
you? And the conservation threshold is a percentage of the net tract area. Is that correct? So if you have 2 different values for the net tract area, would you end up getting 2 different values for the conservation threshold?
Yes, you would.
And did you observe different values for the conservation threshold in this plan?
Yes, I did.
Let's point out just 2 of those examples. Let's go again to the forest conservation narrative box. That's a top middle box. Let's look at, hold on one second. Top middle box.
Number 3 and number 4 are inconsistent.
We're gonna get to that in 1 second. Okay,
Right.
so if we're at the conservation narrative box, we're in paragraph 2. We just read the sentence that since there is no floodplain on the property, the net tract area would be 10.13044 acres. Could you please read the next sentence for us? Starts with a total of 1.154.
Yeah. A total of 1.15540 acres of existing on-site forest and 0.11227 acres of forest clearing is proposed.
And then could you read the sentence after that?
The minimum threshold of forestation required of on the site is 15% of the net tract area or 1.51957 acres.
Okay, so there's several different numbers that we're working with in this box. The ones I want to focus on right now is the roughly 10 acres net tract area and the roughly 1.5 acres to meet the threshold requirement. Is that correct in this box?
Yeah.
Now, let's turn our attention to the Forest Conservation Worksheet box just below to see if those numbers are consistent on this page. So we previously established this provides a different net tract area, is that correct?
Yes.
This provides 12.3 roughly acres for the net tract area, correct?
Yes.
Now, we just said above that the threshold requirement should be 1.5, give or take, acres on this property. What does the Forest Conservation Worksheet provide as the threshold requirement?
Here it says the threshold is 1.84849 acres.
So these are two different values, correct?
Yep.
So is it possible to determine which is appropriate if you have two different values?
No, it causes confusion.
Now, we talked about the threshold requirement. We talked about the net tract area. I want to talk about how the threshold can be satisfied. So, how does an applicant meet the threshold requirement? What does that require on a property?
You have to leave some of the tree stands
Okay, so it can be by preserving the existing tree stands, is that correct?
or replanting other trees.
Okay, and in this plan, what is the applicant proposing to do? What types of strategies is the applicant using?
According to their conservation worksheet,
Yeah, we don't need to worry about the numbers just yet, we'll get to those, but what, are they doing preservation, are they doing afforestation, are they doing a combination, what are they planning on this site?
they're doing a combination.
They're preserving existing forests and planting.
Right.
And why do they need to plant forests to meet their threshold?
Because what they're proposing to retain is insufficient to meet the requirement.
So the planting makes up the difference between what exists on the site and the higher amount that they have to meet that
Right.
threshold, right? So they have to have a combination of preserving existing woodland and planting additional woodland to meet their threshold requirement. Is that correct?
Yes.
Okay, so let's see if they have consistent numbers, or did you observe consistent numbers for how much they're planning to preserve on the site?
No, those numbers aren't consistent either.
All right, well, let's look at the numbers here. So I'd like us to, while we're on sheet 85, let's look at the forest conservation narrative box, again, that top box in the middle of the page. And I'd like you to reread, to refresh our memory, the third sentence that starts with a total of 1.1554 acres. Do you see that sentence?
I'm sorry, you're in the forest conservation narrative.
Yes, paragraph 2.
In paragraph 2,
It's going to be 4 lines down from the title line of paragraph 2. It starts with a total of 1.1.
Yes.
Okay, could you please read that for us?
a total of 1.15540 acres of existing on-site forest and 0.11227 acres of forest clearing is proposed.
So is it your understanding that this is saying they are going to preserve a total of 1.15540 acres of existing woodland on site?
Yes,
And is that number also reflected in the forest conservation worksheet box just below it?
no, it's inconsistent.
Are you sure in the forest conservation worksheet box, if you look at the area of forest to be retained, F, that's the same number, is it not?
Yes.
Okay, but let's turn, if we can, back to sheet 82 of 95. Are you on sheet 82 of 95, Ms. Grover? No. Okay. forest conservation narrative box?
Yes,
And do you see the sticky note above the sentence you previously read?
yes,
Okay, great. And the sentence you previously read was, the church property has no existing floodplain within the Netrex area. Therefore, the 12.32327 acres limits of disturbance is the Netrex area, correct? You previously read that sentence?
yes.
Okay, now I would like you to read the last sentence in this box. It starts with afforestation planting will
Will
be
be-
utilized. Do you see that? Could you please
Afforest-
read that?
Yeah, sure. Afforestation planting will be utilized to address Chapter 50 of the Carroll County Code by protecting 1.07771 acres of existing on-site forest and planting 0.77078 acres of forest adjacent to the existing forested areas for a total of 1.84849 acres of protected forest resources.
Now, thank you, Ms. Grover. I'm a little confused. I thought we just said on the previous page, on page sheet 85, that the existing forest to be preserved is 1.15 roughly acres of property. Did we not just say that?
Yeah,
But is my understanding correct that this sheet now says the amount of forest to be preserved is 1.077 plus a couple more decimal points to be preserved on site?
yes, it does.
Those numbers are not consistent, are they?
No,
And the amount of forest retained on the property impacts how much forest the applicant has to plant, does it not? To meet
Yes.
the forestation threshold?
of course.
Okay, so we've talked about the net tract area. That was not consistent, was it?
No,
We talked about the conservation threshold. That was not consistent, was it?
right.
We talked about the preservation of existing forest. Was that consistent throughout the plan?
No,
Okay, now I'd like to talk about what the applicant plans to provide for additional planting to meet that threshold requirement. I want us to say on sheet 82, I believe you just read this in that last sentence, but how much planting of additional forest does this sheet describe being provided? We just read the sentence that starts with afforestation planting will be utilized to address chapter 150 of the Carroll County Code by protecting 1.0771 acres of existing on-site forest. And then how much planting does it say after that?
and planting 0.77078 acres of forest.
And is that number consistent throughout this plan?
No, there are actually 3 different figures on the plan.
All right, well, let's talk about some of those. Let's turn back. I apologize for flipping back and forth, but let's turn back to sheet 85. That last sheet in the packet, sheet 85 of 96. So I'd like to start on the left-hand side at the top, in the forest conservation easement, forest planting box. There's a green sticky note there right under where it says planting recommendations. Could you please read where it says forest area required? What number does it provide?
Forest area required 0.69991 acres.
Okay, and then the proposed forest planting analysis box, which is just below that, that also says the proposed forest area is 0.69991. Is that correct?
Yes, that's correct.
But the previous, that's a different number than what we just talked about in sheet 82 where they said roughly 0.77. Is that correct?
Yes.
Okay, now let's turn to, still on sheet 85, I want us to look at the forest conservation narrative box. Top middle, we've talked about paragraph 2 in this box a couple times. How much forest planting does paragraph 2 in the forest conservation narrative box say that the applicant is going to provide? I believe it's in the second to last sentence in that paragraph. How much planting?
Minimum on-site forest, less the existing forest is 0.36417 acres of on-site planting. That would, they say, address the afforestation requirements.
But the two boxes we just looked at to the left of this box just said the proposed forest area and the required forest area is .699. Is that not correct?
Yes,
Give or
that's
take a couple
correct.
decimal points.
Right.
So the first page we looked at, the planting was .77. The sheet 85, forest conservation easement says .699, and now we have a .36417 number. Is that correct?
Yes.
Now, what about paragraph 4 in the forest conservation narrative box? What number for the planting is provided in that box, in that paragraph, paragraph 4?
The afforestation required on the forest conservation worksheet is 0.69309 acres.
So we're gonna get to that number. I was talking about the forest conservation narrative box, that's the top middle box, paragraph 4.
This says that retention of the 1.15540 acres of existing forest, on-site planting of 0.78763 acres of forest would meet the afforestation requirements.
Okay, so that says .783. Just above it, it said the requirement is .6417, correct?
Yes, and it's inconsistent.
And then you briefly mentioned this, the forest conservation worksheet box at the middle of the page, on this last sheet. What number for afforestation required did that one provide?
This one says that 0.69309 acres is the afforestation required. That's in subletter H.
So let me see if I have this right. Sheet 82 says the amount of forest that's going to be planted is .77. Then when we look at sheet 85, we have a variety of numbers that include .69991, .36417, .78763, and .66909, or 69309. Is that correct?
Yes, and it does get confusing.
Yeah. So all of those numbers conflict with each other, do they not?
They do.
Okay, so the net tract area, does that have consistent numbers on this plan?
No,
The threshold requirement, does that have consistent numbers on this plan?
no,
Does the amount of forest being preserved on this site have consistent numbers throughout this plan?
no,
What about the amount of planting, which we just talked about? Is that consistent on this plan?
no.
Okay, so I'm gonna go over the last part of this, is the total amount of forest proposed to be preserved on this site. So that should be the combination of preserving the existing forest on that land, and the amount of forest being planted on that property. So, since we're on sheet 85, I'd like us to look at the top left box, the top left sticky note in the forest conservation easement, forest planting information box again. And do you see under the line that says planting recommendations, where the sticky note is just below that, it says easement area acreage provided. Do you see that?
Yeah,
So what total number does that line provide?
the total amount would be 1.79196 acres.
Okay, so that's 1.79196. That's a total amount of forest preservation easement provided by this plan. But let's look at sheet 82. I promise this is the last time I'm going to ask you to flip in this section. Let's go back to sheet 82 for a moment. And I'd like to direct your attention to the forest conservation narrative box in the middle of the page. We've read through this section a couple times. Do you see that box on sheet 82 of 95?
Yes.
Could you, in the last sentence in that box, how much total forest is proposed to be provided under this plan?
says it'll protect 1.0771 acres of existing on-site forest.
And then they're gonna plant what, 0.77078 acres?
0.77078 acres.
And then how much is the total?
The total would then equal 1.84849.
And we just said, did we not, that on sheet 85, the total amount for the forest conservation easement would be 1.79, give or take a couple decimal points. Is that correct?
Yes.
1.79 and 1.84, give or take a couple decimal points. Those are not the same numbers, are they?
No.
So, it's true, is it not, that there's conflicting information about the forest conservation calculations on this plan?
Yes, there are.
And so in your opinion, does this plan satisfy the requirements of the applicable law with this number of conflicting numbers or calculations in the plan?
No, there's no clear demonstration with the requirements of the forest conservation law.
And do you believe the county can determine accurately if this plan meets the requirements of the Forest Conservation Act with this number of errors in the calculations?
Not with this many contradictions.
Okay, so that's one area in which the plan has some issues. I recall you also mentioning that there is an issue regarding the floodplain. Is that correct? So I'd like us to turn to the first sheet of this packet. It should be sheet 1 of 96. And I'd like to direct your attention to the sticky note in the middle of this page in the drawing portion of the plan. Do you see that sticky note?
Yeah.
And what does it describe next to that sticky note?
It identifies the 100-year floodplain on the site.
Now, I'm not an expert at reading plans, so I just want to make sure I understand. Is the 100-year floodplain outlined by this black outline that is the 100-year floodplain label is pointing to?
Yes.
And does that outline for the 100-year floodplain extend south into the subject property?
It certainly does.
And does it appear to be included within the area where there's existing woodland and the existing woodland is proposed to be preserved on the western part of this property?
Yes.
Okay. And now I'd like to turn briefly to sheet 25, which is the second sheet in the packet. Does this sheet, which describes the 100-year floodplain boundary in this area?
Yes.
And it confirms what we just said, that there is 100-year floodplains on the subject property on the western very clearly. And I'd like to see whether or not the drawings for the forest conservation plan also describe the 100-year floodplain. So if you could now turn to sheet 80 of 95. And so this should be the fourth page in the packet. Do you see this page? Do you see 3 sticky notes on this page?
Yeah.
Okay. And you see one sticky note in the drawing area, one sticky note in the forest stand narrative box, and one sticky note in the forest stand legend box. Do you see those sticky notes?
Yes.
Okay, so I want to make sure we're on the same page. So the sticky note in the forest stand legend, what is directly above that?
It's the indication for a 100-year floodplain. It's identified by a dashed blue line.
And do you see that dashed blue line in the drawing above that legend?
Yes, I do.
Is one of the areas of that dashed blue line next to the sticky note in the middle of that page?
Yes.
And is there a label that says 100 FB?
Yes, it does.
In your opinion, does that indicate the 100-year floodplain boundary?
Yes.
Okay, so this plan confirms, does it not, that there is a 100-year floodplain boundary in the subject property. Is that correct?
Yes.
And that the 100-year floodplain boundary is located where there's existing forest that the applicant is planning to preserve. Is that correct?
Yes.
Okay. Now, I would like to take just a moment to take a break from the site to make sure we have our definitions straight. So if we could turn our attention to the applicable law document, that's Appellant's Exhibit 1. I'd like you to turn to page 2, please. And that's labeled at the bottom.
Could you repeat that again?
Yeah,
Just
yeah,
a minute,
page
please, till we
2
get there.
Of Appellant's 1,
Appellant 1, what page?
page 2. And that's page 2 numbered on the bottom.
Not the second page, but what's labeled as page 2. Thank you.
So, do you see a definition for net tract area on that page?
Yes.
Okay, and there are numbers 1 through 5 under that definition, is that correct?
Yes.
Okay, could you please read number 5 for us?
5 states that the existing forest being retained in an easement must be included in the net tract area.
Okay, so, correct me if I'm wrong. When we're talking about the net tract area of this proposed development, it must include the areas where there's existing forest that is proposed to be retained in an easement. Is that correct?
Yes.
And we established a moment ago, did we not, that there's a 100-year floodplain in the existing forest that's proposed to be retained in an easement. Is that correct?
Yes.
And so is it correct to say that because there's 100-year floodplain in the forest proposed to be preserved in an easement, and the forest proposed to be preserved in an easement is part of the net tract area, that the 100-year floodplain exists in the net tract area on this site?
Yes, it does.
Okay. Now, does this plan say in the text of the plan that there's 100-year floodplain in the net tract area?
Yes.
In the text of it? Let's look at it just to make sure.
Well,
So,
there's a note that says there's 0.000 floodplain.
let's be specific. So let's go to sheet 80. Let me just make sure I have our directions correct. Let's turn, for one example, to sheet 82 of 95. Do you see on this sheet a box in the middle on the bottom that says Forest Conservation Narrative?
Yes.
And you see a sticky note. We've visited this box a couple times. Right under that sticky note, it says church property, a sentence that starts with church property. Do you see that?
Yeah.
Could you read that for us?
Church property has no existing floodplain within the net tract area.
But we just showed, did we not, that there is 100-year floodplain that should be part of the net tract area. Is that correct?
Yes, very clearly.
And the existence of 100-year floodplain, of a 100-year floodplain in the net tract area, would that impact the forest conservation calculations?
Yes, because you're supposed to include it when you make the calculation.
Okay, so, microphone off, thank you. So, it's true, is it not, that this plan provides conflicting information about the 100-year floodplain?
Absolutely.
And when this plan provides conflicting information, does it satisfy the requirements of the applicable law?
No, it does not demonstrate conformance with the requirements of the law.
And can the county accurately determine whether this plan meets the requirements of the law if there's conflicting information within the plan?
No.
Okay, so we've said there's inconsistent calculation numbers, did we not?
Yes.
And there's inconsistencies regarding the 100-year floodplain. Was there not?
Yes, there will.
And now, I remember you talking about a third element of this plan, and that's forest clearing. Is that correct?
Yes.
So, To know whether or not there's going to be forest clearing associated with this plan, you would have to know where all of the forest is located that might be impacted by this development. Is that correct?
Yes, that's the purpose of requiring a forest stand delineation in the beginning of the process.
Okay. And now, the law provides a specific definition for what constitutes forest. Is that correct?
Yes.
So I'd like us to turn back to Appellant's Exhibit 1, so we all make sure we know what the definition of forest is. We're going to go to Appellant's Exhibit 1. We're going to go to the first page, numbered 1, second page of the packet. Page number 1. Here we go. Now, do you see a definition for forest in that packet?
Yes.
Could you please read for us the first sentence for that definition?
Sure. A biological community dominated by trees and other woody plants covering a land area of 10,000 square feet or greater.
So, if there's a tract of trees that covers 10,000 square feet or greater, that would constitute forest, would it not?
Yes.
Based on that definition?
Right.
Okay, and based on your review of the forest conservation plan, do you believe the applicant accounted for all of the forest on this property or impacted by this proposed development?
I don't think they've all been included.
Okay, well, let's look at an image of the overall development and the existing condition. So let's turn, if we may, to sheet 80. This is the tricky one. This is 80 of 96. That's the third sheet in the packet. On this sheet, and what appears to be an aerial image of the subject property.
Yes.
And do you see in the middle of the aerial, or let's start at the top. At the top of that aerial image, you see Bachman's Valley Road, MD Route 496. Do you see that?
Correct.
And then bisecting that road appears to be an access road to the subject property. Is that correct?
Yes.
When you reviewed the forest conservation plan, did you believe there were any areas along the access road that would impact or are adjacent to forest?
Yes, they're marked with these stickies right up against the roadway. There are two areas that exceed 10,000 square feet and therefore should be considered forest.
So I want to make sure before we get to that, we're talking about the same place. So are you talking about these shapes that are outlined with these scalloped markings, one of which is to the right of the sticky note on the top part of the page next to the bend in that access road? Is that correct?
Yes, that's a standard marking for edge of tree cover.
Okay, and then is another one of those forest stands that you looked at further south along this road. It's a little more rectangular in shape, next to the second sticky note on the middle or the lower part of this page. Is that correct?
Yes.
I know you said that you believe these stands are more than 10,000 square feet. Is that correct?
Yes.
How did you make that determination?
By using the measuring tool on the county interactive map.
Okay, so before we get into more detail about that, I'd like to show you what we have marked as appellants. Make sure I have the number correct. Appellant 9.
Did you enter 8? I missed it. Okay. Thank you.
And we will go ahead and accept that into evidence as Exhibit 9.
So, okay. So you're talking about the interactive maps measuring tool. So I want to make sure we all know, because we're not all professional land planners. The interactive map is a county-provided map, is that correct?
Yes, it is.
And does it have layers to provide different information?
Yeah, yes,
And does it have base maps that provide different imagery? So for example, you could look at a satellite image, you could look at a topography of the area, is that correct?
yes,
So does the interactive map, you mentioned a measuring tool. It provides a tool to help you measure distances and areas, is that correct?
yes,
And we're looking at this image on Exhibit 9. Does this accurately depict what it looks like when you use the measuring tool?
yes.
So help me understand, what is this blue outline in this shape that we're looking at on the first?
Well, the blue shape was created by clicking around the edge of the shape. And as you can see, to make the curves, you have to come around and make a polygon. And then you're able to click again, and it'll measure the area of that polygon for you.
Okay, so the blue outlines the borders of the polygon that you were measuring, is that correct?
Yes,
And then I noticed a darker shade in the middle of that polygon. Is that created by the measuring tool?
yes,
And does that indicate the area that was measured by that measuring tool?
yes,
Okay, so when you use the measuring tool, you use it to evaluate the size of the two areas of forest that we just talked about on sheet 80 of 96. Is that correct?
yes,
And now, when we're looking at this first image on Exhibit 9, is that one of those areas of forest that you looked at?
yes.
Which area of forest is on this first page?
It's approximately 15,000 square feet of forest adjacent to the road.
I apologize, I didn't speak clearly. Which forest stand of the two that we talked about? Is this the one closer to Bachman's Valley Road in this first image, or is this the one further down the access road?
It's the one closer to Bachman Road.
Okay, and then if we look at the second page of this document, the image that we see, is that the section of forest further down the access road?
Yeah, it's further to the south.
Okay, so let's go to the first page. Approximately how large is the forest stand closest to Bachman Valley Road?
Approximately 15,000 square feet.
So that's more than 10,000 square feet, correct?
Yes.
And then what about, if we turn to the next page, approximately how much was the area of the second area of forest further down the access road?
About 28,000.
Now, you didn't go to the property to measure this, did you?
No.
So this is not an exact measurement of the exact area of this forest, is it?
No, it's approximate, but it exceeds the 10,000 required to define it as forest.
And you measured these two areas using the interactive map multiple times, is that correct?
Yes.
And each time, did you receive a result that was greater than 10,000 square feet?
Yes, I did.
And did you receive results that were within a close amount to the area, the amount provided on Exhibit 9?
Yes.
So Exhibit 9 accurately depicts, does it not, your findings regarding the area of the forest sections along the access road?
Yes, it does.
Okay. So did you, when you were reviewing the site, did you have occasion to believe that these forest stands would be impacted by the proposed development?
Sure, they might be.
All right, well, let's look at sheet 84 of 96 on Appellant's Exhibit 3. This is the second to last page of that. 84 of 96. help me understand, does this sheet show the proposed improvements to the existing site road or access road on this site?
Yes, it does.
And this is not oriented in a north-south direction, is it?
No, it's east-west.
Okay, so on our left-hand side, I see Bachman's Valley Road. That's what we identified at the top of the last image we were talking about, correct?
Yes,
And then as we travel through this page towards the, I apologize, east. Thank you. Do you see a sticky note in the middle of the page?
yes.
Now, what is next to that sticky note?
It's a road and a proposed alignment.
And do you see, I know it's very faint, but do you see a faint outline of a scalloped shape that you said indicates forest cover?
Yes, it's here. It's not that easy to see. It's very light, but it's definitely there.
And is it your understanding that that scalloped area indicates that first area of forest cover that we talked about in Exhibit 9 a moment ago and on that previous sheet a moment ago?
Yes, it does. I
And then-
believe it does.
Do you see a second sticky note on this sheet?
Yes,
Further east? Or further south, I believe. Is that next to a scalloped shape? Again, it's a little difficult to see unless you look very closely.
yes, I see it.
And does that indicate a forest stand?
Usually that's edge of tree cover, yep.
And is it your understanding that that depicts the second forest stand that we talked about in Exhibit 9?
Yes, I think it does.
Now, I see these dark black dotted lines along the proposed road improvements. Does that indicate the limits of disturbance for these proposed road
Yes,
improvements?
yes, it does.
And based on the scalloped shape provided for the forest stands and based on the limits of disturbance, is it your opinion that parts of these two forest stands are within the limits of disturbance on this plan?
Yes, they are.
And is it your opinion that in order to provide these road improvements, some forest clearing would have to occur in these forest stands to accommodate that limit of disturbance?
Yes, I think they would be effective.
Now, I know we've gone over this a couple times. Does the plan provide accurate and consistent information about forest clearing on this site?
It can't because so many of the numbers are inconsistent.
All right, well, let's talk about it. We're just gonna flip one page to the last page of this document. Again, we're on sheet 85 of 90. Now, we've covered a lot of the inconsistencies with other areas, but we haven't specifically talked about forest clearing. So I'd like to direct our attention back to the forest conservation narrative box. That's the one in the top middle. And I'd like to point our attention to paragraph 2, determination of reforestation requirements. Do you see that?
Yes,
And then do you see the third sentence? It's 4 lines down. It's such a total of 1.1554 acres.
yes.
Could you please read that for us again?
A total of 1.15540 acres of existing on-site forest and 0.11227 acres of forest clearing is proposed.
Okay, so this box is telling us 0.1122 acres of forest is being cleared. Is that correct?
Yes,
But it doesn't tell us what forest this is talking about. Is that correct?
right.
Let's look at the forest conservation worksheet box to see if this provides consistent information with what we just read. Do you see that box just below in the middle of the sheet?
Yes,
How much forest clearing is described in this forest conservation worksheet?
it says there won't be any clearing, 0.0 acres.
So a sentence that says they will clear 0.11227 acres in a sentence that says they will not clear any acres of forest, that's not consistent, is it?
No,
And the amount of forest that's cleared impacts how much forest the applicant has to plant or preserve on the site. Is that correct?
Sure.
So if you have two different numbers, can you accurately determine how much they're required to plant or preserve on this site?
No, it's left up in the air.
And can the county then determine, if you can't determine how much they're required to provide, because you don't know how much they're going to clear, can the county accurately determine whether or not this plan meets the requirements of the Forest Conservation Act?
I don't see how they can.
Okay, so just to summarize, we have inconsistent calculations, is that correct?
Yes.
We have inconsistent descriptions of the existence of the 100-year floodplain, is that correct?
Yes.
And we have inconsistent descriptions about the amount of forest clearing on this site, is that correct?
Yes.
So in your opinion, with all of that being considered, does this plan satisfy the requirements of the law?
No.
Okay, thank you. So I'm going to conclude my discussion of the forest conservation plan. I'm going to move to the specimen tree variance. Would the board like me to continue? Do we want to break at all? I just wanted to make sure.
Before we go into the, let's allow questions on what has taken place, the testimony that's taken place so
Absolutely,
far.
sir. Yeah.
So does anyone in the audience have any questions? Okay. Ms. Moore?
Yes, I do have a couple things. Thank you, first, Ms. Grover, for being here. We appreciate it this morning. I'd like to go back very quickly to your experience. You are a planner by nature, correct?
Urban planning, yes.
Do you have any specialized tree specialist background, any forest conservation specialist knowledge?
Well, I have 41 years of experience, and I was deputy director in St. Mary's and oversaw a staff. And in Prince George's, I was a case planner. So when you're working in a capacity like that, you're responsible for including an environmental write-up in your staff report. So I would refer out the plans and get comments back and include whatever was necessary in my staff report to accurately describe things like we're dealing with today. You know, what trees are on the site, what trees have to be removed, where do you have to reforest.
But you would,
was part of it.
you would not say that you're a forest conservation specialist, though, by nature?
No, but I had a lot of contact with it over the years and a lot of years of experience.
Thank you. Are you aware where the plans that we have been discussing today, I believe it's Appellant's Exhibit 3, where they were specifically pulled from, how they were received?
Yes, this Macy Nelson staff pulled it from your archives.
All right, thank you. And are you aware if this plan in front of you today is the final conservation plan?
I believe it is.
And are you aware if any conversation has been had at this point about amending these plans prior to today?
I have not been involved in any plans regarding amending the plan.
All right, thank you. No further,
Any discussions regarding amending the plan.
no further questions.
Okay. Board members, questions? Who wants to go first? Mr. Caldwell.
Do you have dates for when each of these maps were made?
On exhibit,
On the exhibit, well, on Exhibit 9 and also on the Exhibit 3?
They were made in Macy Nelson's office, so can I ask them to address the exact dates? Because I don't know exactly what date they were generated. It was recent.
Well, what I'm concerned about is you've got an aerial view in one of the sheets. I want to know, you know, when was that?
Well, it was pulled from your interactive map, so.
When? This is from 2021. So we're looking at information on different years.
May I address that?
Yes.
So the sheets that we have provided to you in Exhibit 3 are pulled from the county's website, and they are the most up-to-date plans that the applicant has submitted to the county. So I can't personally speak to what time the aerial imagery provided in this plan was taken. It was provided by the applicant themselves. As it
Well, Mr.
relates,
Let me interrupt. Mr. Caldwell saying that the plan that you have on the easel is from
2021.
2021. And he was trying to determine a date that you used the county's website in
Exhibit 9.
Exhibit 9.
Exhibit 9, yes. So I apologize, I was about to get there. I probably should have started there. So we created, our office created the Exhibit 9 to reflect Ms. Grover's findings. We did that, I can't tell you directly off the top of my head, within the past 2 weeks. I created that exhibit, and it's from the imagery base layer provided on the county's website. The interactive map doesn't give me it doesn't give us, as far as I recall, a specific date for when that imagery was taken by the satellite that took it. But it's, as far as I know, the most up-to-date imagery provided on the website, and as far as I could tell, matches what was provided in the plan submitted by the applicant.
Okay, second question is concerning applicants' Exhibit 9. Your measurement area includes area of road surface.
When you use the measuring tool, as Alex described, it's somewhat variable depending on where exactly you click. But we did the calculation many times, and the pivotal thing is it over 10,000 square feet or not? If it is, it's considered forest, and it needs to be counted in your forest conservation calculations. And every time we clicked around a polygon that approximated the forested area, it was always over that. So, I mean, that's what matters in the end.
Okay, but it's for the sense of accuracy here, since you're going into numbers to several decimal places, one would expect that the calculations would actually show a polygon that outlines the road, because we didn't drive through trees when we went to our site visit. I'm just making a point, if you're being that precise with numbers, these numbers don't match up either. That's all, sorry. I have no further questions, thank you.
Ms. Ford Mount? Ms. Eckert?
Thank you so much for your testimony, and you are right, this does get a little bit confusing, but I have several questions. So, one of the recognizing that there are inconsistencies clearly between what's in the calculations and the narrative throughout the site plans that were provided. Acknowledging that, my first question to you is, in addition to just saying, oh, there's an inconsistency here, there's one there, did you actually take any time and analyze any of the calculations, assuming, like for instance, the first inconsistency pointed out was it was 12.32327 acres versus 10.13044 acres of net area.
Yeah.
Which is roughly a 2.19 acre difference. There was discussion that the floodplain, as indicated in the narrative, was not included in this acreage, in the net acreage. But when I look at the forest conservation worksheet that has the actual numbers, what the calculations are, do you know if the area of that floodplain is the 2.19 acres, if that's the difference?
We didn't go that far in our calculations. We found so many different discrepancies, we thought that they were kind of, that they needed correction before the calculations could be done, before the judgment could be made that this was an approvable forest conservation plan.
But is it possible that that 2 acres was floodplain based on your knowledge that you've discussed and your experience? Does that look like it could potentially be roughly 2 acres? may.
It might be, but the work needs to be done, and the work should be done before the plan is approved, not after the plan is approved.
Again, recognizing, my first statement, I think, was recognizing that there are inconsistencies. I'm just trying to get the whole picture as
Yeah.
to how much analysis was done.
Yeah.
So, the forest conservation worksheet indicates that it was based on the higher acreage, the 12.32327 acres. So, based on your review of this plan, were the calculations actually based on the higher acreage that was cited in this plan? Recognizing the discrepancy between the 10 and the 12 acres, were these calculations for the required reforestation based on the higher acreage?
On the worksheet, the net tract area they used was the 12-acre number.
So assuming that that net tract area of 12 acres is accurate, are all of these other calculations correct? Because it appears that that would be requiring more forested area if it's based on the larger acreage.
Well, it requires .69309, and it's a problem in development review. Usually you review the plan that you're given, and to go into all the shoulda, woulda, coulda, it's just it's not the job of the reviewer. It should be clear on the plan. Conformance with the law should be demonstrated on the plan, and the applicant here failed to do that. The burden is on them to demonstrate conformance with the plan.
So at this point, I'm recognizing we're sitting here in a hearing, would it be your opinion that it would be appropriate to have the inconsistencies in this plan corrected?
Of course, they should, by the applicant, it should all be corrected, and if they can demonstrate conformance, then it should be approved. But this plan should not have been approved in this manner.
So you're indicating that if they make these corrections and it's in conformance with the requirements that you detailed that would indicate, or excuse me, that dictate that this plan be accurate, then it should be approved?
Provided it's in conformance with the woodland conservation law.
Thank you.
I have one question. Exhibit 9 shows the improved roadway.
Yeah,
Who owns that property?
we know. I believe it's the applicant or the church.
Okay. It wasn't delineated on the plan, that's why I asked that question. So the church actually owns that property that goes, the long, semi-improved driveway.
We submitted one exhibit that shows the larger acreage that the church and the applicant together own. That was, oh, you didn't show it yet? Oh, it's about 50 or 60 acres, sizable piece of property.
I hate to interrupt, but I believe the applicant is here if we'd like them to confirm very briefly on this, if you are open to that.
Will the applicant be called as a,
No.
we'll go ahead and wait. Thank you. Any other questions, board members? Ms. Moore?
No further questions.
Okay. Thank you very much for your testimony.
I have
wait.
additional for the specimen tree part of it with Ms. Grove.
Oh, that's right, that's right.
That's
Sorry.
right.
You're stuck with me for a little bit more. Thank you. Okay, oh, there, that's where it is. All right, so we covered the forest conservation plan. Now, Ms. Grover, I'd like to turn our attention to the variance application. Have you had the opportunity to review the section 150.14 regarding the requirements for a variance to the Forest Conservation Act?
Yes,
Okay, great. And have you, I'd like to turn our attention to that requirement. So if we go back to Appellants 1, the applicable law packet, and I'd like I'd like you to turn to page 12, numbered on the bottom of that packet. Do you see at the top, it says section 150.14 variances? And then do you see, about halfway down the writing, section C?
Yep.
Could you please read section C for us?
A written request for a variance shall be submitted to the county and shall state the specific variance sought and the reasons supporting the granting of that variance. A variance may not be granted unless and until sufficient specific reasons justifying the variance are provided to the county such that it is proven that the purpose of this chapter will not thereby be compromised.
And then after that, it says an applicant for a variance shall, and then it lists several criteria the applicant has to demonstrate conformance with. Is that correct?
Yes, that's correct.
Okay, so and have you had the opportunity to review the variance application?
Yes, I have.
And the document you reviewed is the same as what we have submitted into evidence as Appellant's Exhibit 4. Is that correct?
Yes.
Okay. And have you had the opportunity to review the Director Hines' decision, which we have submitted into evidence as Exhibit 7?
Yes, I have.
Okay. So I want to start by just looking at the application itself. So if you want to pull up Appellant's Exhibit 4 for you. Okay. So the statute requires that the variance request shall state the specific variance sought. Is that correct?
Yes.
And that specific variance sought must be accurate. Is that correct?
Yes.
So from your review of the Forest Conservation Plan, how many specimen trees is the applicant proposing to remove?
They're proposing to remove 5.
And how many trees does this variance request discuss?
It only discusses 4.
So there's a 5th tree, I believe it's titled numbered specimen tree number 5, that's not described in this variance. Is that correct?
Yes.
So in your opinion, does a variance application accurately state the specific variance sought if it does not include all of the trees proposed for removal?
No, it does not.
Now, the ordinance also requires that the applicant provide in writing the reason supporting the granting of the variance. Is that correct?
Yes.
And now I want to look at the variance application itself. Do you see Appellant's Exhibit 4 on the first page? Towards the bottom, there is a section that says explain variance request. Do you see that? This section provides the applicant an opportunity, does it not, to attach copies to plans and supporting data, attach additional pages of explanation if needed as well. Is that correct?
Yes, it says right on the form.
Did the applicant provide any additional information other than the 2 sentences provided in this section?
No, they simply said they met all the requirements, but they didn't demonstrate how they met all the requirements.
Now, the statement on the first page where they're explaining their variance request, and they say, do they not, that they want, the only explanation provided there says removal of specimen trees 1 through 4, period. The trees are in conflict with planned site improvements and reasonable alternatives have been exhausted. That's what this says, correct?
Yes.
Does this explanation adequately address all of the required criteria listed under section 150.14C?
No, there are 5 criteria there, and it doesn't go into any detail on any one of them.
So I'd like to turn to the second page of this application. Again, second page of Appellant's Exhibit 4. Now, is it your understanding that this is a short form used by the county for variance requests related to specimen trees in poor and fair conditions.
Yes.
And you got that understanding, did you not, from the director's opinion regarding the forest, specimen tree variance? Is that correct?
Yes, he states that in there.
Now, do you believe placing an X next to the statement, the trees are in conflict with planned site improvements and reasonable alternatives have been exhausted, adequately demonstrates, for example, or adequately describes the special conditions or exceptional circumstances peculiar to the property?
No.
In your experience, does a conclusory statement, unsubstantiated by any additional information, that that an applicant satisfies criteria, is that sufficient justification for an application? in your
No, it
experience?
only says that they satisfy their criteria. It doesn't say how they satisfy the criteria.
So in your experience, an applicant for a variance or an application would have to provide evidence to support their statement that they believe they meet these criteria. Is that correct?
Yeah, we used to routinely get statements of justification and applications in Prince George's.
And if an applicant doesn't provide that information, it would be difficult, if not impossible, for the county to determine whether an applicant meets the criteria. Is that correct?
Right.
Okay. So in your opinion, does this variance application satisfy the requirements set forth in section 150.14?
No.
Now, I want to speak briefly about some of the statements made by the director in his opinion. You said you're familiar with his opinion, correct?
Yes.
Are you familiar with the statement made in that opinion that the department has a policy of using the short form for the trees in fair and poor conditions?
Yes.
Now, in your experience, if a department level policy conflicts with the statutory requirements set forth in state law or a local ordinance, which controls, the statute or the policy by the department?
The statute always trumps.
Okay. And in your opinion, is a department policy that doesn't meet the requirements of a law sufficient justification to approve an application that also does not meet the requirements of a law?
No, it is not.
Similarly, are you familiar with the statement that the department, made by the director, that the department does not require variances to remove dead specimen trees?
Yeah, I'm familiar with it.
So from those two statements, that they use a short form for specimen trees in poor and fair condition, and that they don't require a variance for trees in a dead condition, do you take those two statements to mean that the department imposes different standards for reviewing variance requests for trees in poor, fair, or dead conditions than the county applies to variances to remove trees in excellent health, for example?
Yes. Again, it's not supported by the law that removing a dead specimen tree does not require a variance.
And let's get more specific. Does anywhere in the Forest Conservation Regulations, that's Chapter 150, allow the county to apply different standards to variance requests based on the health of trees?
No.
So again, that policy conflicts, does it not, with the ordinance enacted by the elected officials in this county. Is that correct?
Right.
So again, in your opinion, does this variance application satisfy the requirements of the law? Just what has been provided by the applicant?
No.
Okay. Now, to wrap this up, I want to talk about the variance criteria. You're familiar with the variance criteria in section 150.14?
Yes.
Are you familiar with the requirement in section 150.14 that states, let me be specific, the applicant must describe special conditions or exceptional circumstances peculiar to the property? Are you familiar with that term?
Yes.
Have you had occasion to consider what that term requires an applicant to show?
Yes, I routinely did variance applications for site plans.
Now, it's true, is it not, that variance requests and variance criteria might differ amongst different counties, correct?
Yeah, they're worded differently, but the basic idea carries through.
And you're familiar specifically with the terms special conditions or exceptional circumstances peculiar to the property, correct?
Right, yes.
And in your opinion, what does that criteria, what does that term require?
It requires uniqueness for this property as against all the properties in the surrounding area.
And what type of characteristics would you look at to determine whether a property is unique compared to other properties?
Size, shape, environmental resources on the property.
Is topography something you would look at?
Yes, especially steep slopes become an impediment to development sometimes.
And did you have occasion to review the size, shape, topography, and environmental resources that exist on this site?
Yes, I looked at that.
And did you find that those elements were unique to this property in a manner different from other properties in the area?
No, if you look at the maps that are available, they share these kind of features with a lot of the surrounding properties.
All right, well, let's get specific. So I'd like to show you what we will mark as appellants. I believe we're at 10. That one's for you. And of course, I'm going to hand that out to everyone. Oops, sorry. Sorry.
We will accept this as applicant's number 10.
Thank you. So what are we looking at in this image, Ms. Grover?
This is a screenshot of the subject site and the access off of Bachman Valley Road.
So the red outline outlines the subject property and the road they used to access that property. Is that correct?
Yes.
And you had the opportunity to review the subject property through the county's interactive map. Is that correct?
Yes, I did.
And you use the imagery base layer. That's what we talked about a few minutes ago. It doesn't provide a date for that satellite image, but appears to be the most recent image available on the interactive map. Is that correct?
Yes.
And does this image accurately depict, with the addition of a red outline along the area that we're focusing on, accurately depict what you reviewed on the interactive map?
Yes.
So based on the outline of the subject property, do you believe it's particularly unique in shape?
No, it's actually very rectangular. There isn't anything unique about the shape.
And in fact, to that point, the applicant describes on plan sheet 80 of 95 that the property is rectangular in shape. Is that correct?
Yes.
Okay. So based on your review of the shape of the property, it doesn't appear particularly unique. Are there other rectangularly shaped properties in this area?
Yes, there are.
Now, are you familiar with how large this property is?
Yes, about 25 acres.
And in comparison to the other properties in this area, does the size of the property seem particularly unique?
No.
Are there other properties that are smaller than this property?
Some smaller, some bigger, some about the same.
Okay. So there's nothing unique about the size of this property?
No.
Now, I'd like to show you what we have. Sorry, before I do that, have you had the opportunity to review the topography of the subject property?
Yes, I have.
And how did you review the topography of the subject property and the surrounding area if you looked at that?
On the interactive map and utilizing an exhibit that was generated by your office. That makes it a lot clearer.
Okay, so the interactive map, am I understanding correctly, it has a base image that shows the topography lines, the elevation lines on this property and in the area around it?
Yeah, but just not very clearly.
Okay, so I'd like to show you what we will mark as Appellant Exhibit 11. That's here for you. And let me get that around to everyone else. There we go. Now, we're going to talk about this image. I'm gonna wait for everyone to have a copy of it.
And we will accept this into evidence as applicant 11.
Thank you, sir. So this first image on Exhibit 11, does that accurately depict a screenshot of the topography layer on the interactive map?
It does.
I see very faint lines throughout this image if I look very closely. Are those the topographic lines provided on the interactive map?
Yes.
And on the interactive map, do those lines become more clear if you zoom in to a smaller area?
Yes, they do.
So you can read those lines if you had access to a computer and you're able to zoom in. Is that correct?
Yes.
But it's difficult, both on the computer and on this image, is it not, to see those lines from a wider perspective. Is that correct?
Yeah.
So I'd like to turn to the second sheet of this exhibit. I'm seeing a lot of colors. It's true, is it not, that my firm provided this image to you. Is that correct?
Yes.
And is it your understanding that the various colors throughout this image represent different layers or levels of elevation depicted on the interactive map? Is that correct?
Yeah, they're different grades.
So one color or one band corresponds with the bands and the lines provided on the interactive map. Is that correct?
Yeah, these are 20-foot intervals.
And so based on your review of the interactive map and your review of this image, do you believe the colors added to this accurately depict the elevation and topography shown on the interactive map, but with additional colors to make it easier to read? Is that
Yes.
correct?
Yes.
Okay, so and of course the red outline that's provided, that's not on the interactive map. Is that correct?
Right, that's the subject site.
So our firm added that red outline of the subject property. Is that correct?
Yes.
But that outline accurately depicts the approximate location of the property boundaries as depicted on the interactive map. Is that correct?
Correct.
Okay, so I'd like to go through the numbers and the colors just briefly so we know what the heck we're looking at on this picture. So my understanding is that one color represents one level of elevation measured on that topographic map. Is that correct?
Yes.
So if you have an area that is a large area of the same color, that would indicate a large area of land that's within that 20-foot increment. So the elevation in that area would be between, let's say, 920 and 940. Is that correct?
Yes.
Depending on the color, it would associate with a different groupings of elevations. Is that correct?
Yes.
And so if you see areas where there's many colors in close proximity and the bands are thinner, does that indicate changes in the elevation on that property?
Specifically, it would indicate a steeper slope.
Okay, so the closer together the changes in color are, the more the elevation changes and the steeper the slope would be. Is that correct?
Yes.
And inversely, the wider apart the changes in colors are, the less colors on a certain property would indicate less change and less steep slopes. Is that correct?
Flatter land.
Flatter land, okay. So I'd like to take a look at the subject property. How many different colors and therefore elevations are represented on the subject property?
Looks like there are only 3.
So at maximum, the change in grade for this property would be about 60 feet. Is that correct?
Right,
And that's over the span of 25 acres.
right.
In your experience, is that change in grade over that amount of space particularly steep?
No.
Would you describe it as more flat?
Yes, it would be more flat.
And does the change in elevation, the topography of the subject property, differ in any significant way to other areas in other properties in the area?
Yeah, the slopes are steeper on some of the surrounding properties.
So other properties have more steep slopes and are more burdened by the topography than the subject property. Is that correct?
Yes,
And there are other properties in this area that have less steep slopes and flatter property. Is that correct?
yes,
That's similar to the subject property.
yeah.
So in your opinion, does the topography of the subject property make it unique? Is that a special condition or exceptional circumstance peculiar to this property?
No,
Okay. Now, what about environmental resources? Did you have an opportunity to consider the environmental resources on the subject property?
yes,
And did you use the USGS base map layer on the county's interactive map to review those environmental resources?
yes.
Okay, so I'd like to show you, let me get myself organized for a moment, what we will mark as Appellant's Exhibit 12. Yeah, and then this is, sorry, Ms. Grover. And this one for you.
And we will accept this into evidence as Exhibit 12.
Now, does this first image on the page accurately depict what the USGS National Base Map layer looks like on the interactive map?
Yes, it does.
So this is a representation of what you reviewed on the interactive map. Is that correct?
Yes,
And now, does the interactive map provide a key on the map itself for what the different symbols mean? So for example, what the green area means, what the little triangular plant-like symbols mean, or what the blue point your attention to towards the bottom right, a box that's titled vegetation. And then it has various green symbols and boxes underneath that. Do you see that?
yep.
So what does the solid light green color represent according to this legend?
It represents woodland.
Okay, so now we know, do we not, that on Appellant's Exhibit 12, the green areas demonstrate the approximate location of woodland. Is that correct?
Yes,
Okay. And I'd like to go back to 13, Appellant's 13. We're still on page 4. At the top of this document, on the right-hand side, there's a box titled Submerged Areas and Bogs. Is that correct?
yeah.
And does this indicate that the plant-like symbols indicate on the map marsh or swamp?
Yes, they do.
And when that symbol is located on top of a green background, that indicates marsh or swamp within a wooded area. Is that correct?
Yes, it does.
And generally, marsh or swamp is areas that might be like, for example, a 100-year floodplain or wetlands. Is that correct?
Yes,
Okay.
some kind of wetland.
Yeah. So let's go, now that we know what the symbols are, oh, I apologize. Let's also talk about, on the top left side of page 4 of Exhibit 13, there's a box titled Rivers, Lakes, and Canals Continued. Is that correct?
Yes.
And the top image where there's a light blue surrounded by or bordered with a border of darker blue, that indicates a perennial lake or a pond. Is that correct?
Yes.
And then if we turn to page 3 of Exhibit 13, the bottom right hand is the beginning of the Rivers, Lakes, and Canals key. And this demonstrates, does it not, that the blue line represents streams. Is that correct?
Yes.
Okay. So now we can turn back to Exhibit 12, which is the screenshot of the interactive map base layer. So now we know, do we not, that the green background is woodlands, that the vegetation symbols are submerged, marshy, flood-prone areas, and the blue circles and the blue lines are streams. Is that correct?
Streams or ponds.
Or ponds, yes, correct. Thank you. And now I'd like to turn to sheet 2 of Exhibit 12. My office provided you this image, did it not?
Yes.
And it's your understanding, is it not, that my office used the screenshot from the USGS National Base Layer and cleaned up the coloring to make it a little easier to read. Is that correct?
Yes.
So, for example, my office added the red outline around the subject property and the road, access road. Is that correct?
Yes.
And my office outlined the green areas in a darker green to make sure it's clear where those areas are. Is that correct?
Yeah.
And my office also removed the shading and the topographic lines so that we could just focus on the environmental resources. Is that correct?
Yes.
But even though there are these slight changes, do you still believe sheet 2 accurately depicts the approximate location of the woodlands, streams, ponds, marshy areas that are depicted on the first image from the original USGS National Map Base Layer?
Yes.
Okay, so I'd like to focus on page 2. We see, do we not, that there are woodlands and a stream and some marshy wetland type areas on the subject property on the western side of the property. Is that correct?
Yes, in a small pond.
In a small pond. Do those environmental resources extend throughout the subject property?
No, they're nowhere present on the balance of the northeastern portion of the property.
So it's fair to say, is it not, that these resources are concentrated to a small portion of the subject property on the westernmost part of the property. Is that correct?
Yeah.
Okay, and so there are environmental resources, but in your opinion, does the existence of this combination of environmental resources make this property unique?
No,
Why not?
because it's present on other properties in the vicinity.
So there are other properties close by that also have these same environmental resources. Is that correct?
Exactly.
And would you think it's fair to say that there are other properties in this area that might be more burdened by these environmental resources compared to the subject property?
Yeah.
So nothing about the environmental resources, their existence, or their distribution makes this property peculiar or unique compared to other properties. Is that correct?
Yes.
All right. So we've talked about the shape of the property is not unique, correct?
Right.
The size of the property is not unique. Is that the property? Does that make a property unique?
No.
I'd like to turn your attention to what we previously marked as appellants 5, which is a screenshot from the Forest Conservation Plan, one of the sheets numbered 80, where my office added an outline of the specimen trees in red to clearly delineate where they are in the property.
Which page are we on in Exhibit 5?
Exhibit 5, page 1.
Page 1, very good,
Yeah.
thank you.
Absolutely. Now, there are only 9 specimen trees on the subject property, is that correct?
Yes.
Is having 9 specimen trees on a 25-acre property stand out as particularly burdensome or unique to this property?
No.
Does the applicant provide the county with any evidence in its application about the amount of specimen trees located on other properties nearby?
No.
It's true, is it not, that the specimen trees are mostly located, or I would say exclusively located, on the western portion of this property? Is that correct?
Well, centrally, yeah.
And that, is there any evidence that there are specimen trees located on any other portion of this property?
There's one on the far west. No, there aren't any.
On the eastern side of the
On
property?
the eastern side of the property, there are no
So
specimen
the,
trees.
and the eastern side is not wooded, is that correct?
Right.
So there are only specimen trees located on the westernmost part of this property, and there, to your understanding, are no specimen trees or woodlands or environmental features or extreme topography on the eastern side of this property. Is that correct?
Yes.
Now, is there anything about the location of these trees that screams that they're unique to you in your experience?
No.
Okay. They're not distributed throughout the entirety of this property, are they?
No.
They're located in a specific small area of this property near the other environmental resources. Is that correct?
Yeah, they're really clustered.
Okay. So there's, I believe, is it accurate to say that there's nothing that establishes that this property is unique in any way? Is that correct?
I would agree.
Okay. So now I'd like to go to the undue hardship criteria. In your experience, what does undue hardship mean?
Undue hardship means something affects the property owner much more than similarly situated property owners.
And is it fair to say that a justification that the trees are in the way of what we want to do, is that sufficient to establish by itself an undue hardship?
No, and it's not in the law that is sufficient justification.
Is it fair to say you would have to show, for example, you can't locate or redesign the site to avoid the need for the specimen trees? Is that correct?
Right.
Did the applicant provide any evidence, aside from a conclusory statement that's unsubstantiated, that it's unable to move this proposed development over a couple tens of feet or redesign it to avoid the impact of the trees?
No, there was no information like that in the application, although, as you pointed out, they gave a space for the applicant to provide that kind of justification, but nothing was provided.
And I recall, do I not, that the net tract area of this property is anywhere between 10 and 12 acres, depending on which calculation you rely on. Is that correct?
Right.
But the subject property itself is 25 acres. Is that correct?
Yes.
The vast majority of which is unburdened by specimen trees or environmental resources?
Right.
So would you say that just based on the subject property itself, retaining those trees would cause an undue hardship to the applicant?
No.
Now, did you have occasion to review the ownership of the properties around the subject property?
Yes, we looked at that on the interactive map.
And now, walk me through that. How do you figure out what the ownership is of a property on the interactive map?
Well, you click on the property, and then you go to more information, and it gives you the property owner.
Does it show you, does it link, for example, to the state tax records in the SDAT?
Yeah, which is your most reliable source of ownership information. As you can imagine, the county wants to get their taxes.
And when you reviewed the ownership of the properties around the subject property, did the church for which this plan is proposed own any of the property adjacent to the subject property?
A considerable amount of it.
All right, so I'd like to show you what we will mark as Appellant's Exhibit 14.
And we will accept that into evidence.
Now, just to orient ourselves, this is the imagery base layer from the interactive map we've talked about a couple times. Is that correct?
Yes.
And it's correct that my office added the red outline. Is that correct?
Yes.
So what is that red outline showing?
The red outline shows property that's owned by the church or the applicant.
So the applicant or the church owns all of the property based on your review of the publicly available documents through SDAT and the interactive map, owns all of the property within that red boundary. Is that correct?
Yes.
And a large area of this property is not burdened by environmental resources or woodland, is it?
No.
Now, did you have occasion to investigate approximately how much property within that boundary is unwooded in that area?
A good bit of it.
So you did investigate that?
Yeah, I mean, you can just tell from the imagery too. It's about 60 acres and there are tree stands here and there on it, but there's a lot of clear land too.
So when you say it's about 60 acres, how do you know that it's about 60 acres of area on this property that's unwooded, doesn't have trees on top of it?
We used the measuring tool and measured it.
So you use the interactive maps measuring tool that we discussed previously, is that correct?
Right.
And so did you use that tool to essentially outline the areas of the property that were within that red boundary we just showed that did not have forest on top of it? Is that correct?
Yes.
So I'd like to show you what we will mark as Exhibit 15. So
We will accept this into evidence also.
So just to orient ourselves, this is a screenshot, is it not, of the interactive map with the imagery base layer and the measuring tool being applied to the areas we just described. Is that correct?
Yes.
This image was created by my office. Is that correct?
Yes.
And when you measured the unwooded area, did you get a substantially similar result?
Yes.
So do you think it's accurate? Do you think this image accurately depicts the substance of your finding that there's approximately a little bit less than 60 acres of property that's unwooded, that's owned by the applicant or the church?
Yes.
Okay. And so, given the amount of unwooded property on the subject property and the amount of unwooded property owned by the church itself, do you believe it's an undue hardship if the applicant is required to retain 5 specimen trees located on the westernmost portion of the subject property?
No.
Why is that?
Because there are a lot of other places where the buildings could be placed.
And the last point I'd like to make about the undue hardship piece is regarding the site plan. Now, on the first sheet of exhibit, I'll just get up and do it to be clear. So I'm going to turn to the first sheet of Appellant's Exhibit 3, the site plans. first sheet, do you see on the left-hand side at the top a green sticky note next to site general note number 6?
Yes,
And is site general note number 6 titled parking tabulation?
yes,
And under that, does it describe the number of seats being provided in this religious establishment?
yes,
How many is that?
500,
And then in the next line, does it describe the maximum capacity for uses on this site?
it's 500,
So the applicant's requesting the maximum amount of seats, the maximum amount of development permitted on this site. Is that correct?
yes,
And a few rows down, does it also describe the parking spaces required?
yes,
And how many is that?
it's 125,
And then does it describe the total parking spaces provided?
133,
Now, that's more parking than is required by law. Is that correct?
yes,
So in this case, we have more parking than is required by law, and we have maximum capacity being requested. Is that correct?
yes,
Now, the applicant's entitled to request that, are they not?
yes,
But they have to meet the requirements of the law, isn't that correct?
right,
And does a request to provide more than is required parking spaces at the maximum capacity permitted for this site justification for an undue hardship when they have, what we've established is roughly 60 acres of unwooded property that they could utilize?
No, I mean, asking for the maximum amount of development allowed should be based on meeting the other statutory requirements, including requirements for variances, requirements for woodland conservation.
All right, thank you. I'm gonna come back over here. So, given the amount of property available on the subject property that's unwooded, given the amount of unwooded property owned by the church adjacent to the subject property, given the amount of, given the capacity requested, given the amount of parking spaces provided, given the fact that the specimen trees are closely clustered and located only on a small portion of this site, do you think the applicant would experience an undue hardship if they were required to retain the 5 specimen trees on site?
No, I do not.
And do you believe that the need for the variance is instead caused by actions of the applicant?
Yes, specifically where he's insisting on placing these improvements.
And do you believe that the extent of this proposed development could adversely impact water quality in the stream and the 100-year floodplain located directly adjacent to it?
Water quality and indirectly air quality, which are two goals of the woodland conservation ordinances.
Thank you. So I just want to summarize. Do you believe the forest conservation plan itself meets the requirements of the law?
No, it does not.
Do you believe that the variance application meets the requirements of the law?
No, it does not.
Do you believe the applicant provided sufficient evidence and consistent numbers that would allow the county to determine whether or not they meet the requirements of the law?
I know that he did not.
And do you believe, based on the evidence that we just described, that the applicant could meet the requirements for a variance to remove specimen trees?
No.
Okay. That's all I have. Thank you so much.
Ms. Moore?
You know, I cannot stay quiet over here. I'm going to kind of break this down into pieces since we did review a number of things, so we'll walk through this part by part. I'm going to go back and first touch on the tree number 5 that we noted, the potentially dead tree. You had stated that you believed that the dead tree should be included in the tree variance request, correct?
We did not find any reason to exclude it.
So under this argument, are you saying that every dead tree must have a variance request to remove it?
Every dead specimen tree should have a variance to remove it.
Despite the potential safety hazards that it could present?
I'm sure there's a separate mechanism for safety hazard, for indicating a safety hazard.
Thank you. I'm going to kind of look at our discussion now of the special conditions, the peculiar, the uniqueness discussion that we had. So in that, you noted that size, shape, topography all play part of whether something is a special condition or peculiar. Are there other things that could be considered outside of those three as well?
Well, just going off of the words of the ordinance, those are the words of the ordinance. I
Does
suppose
the-
something else could make it peculiar at some point in time.
And so you're saying that the ordinance specifically only notates size, shape, topography? Could you point to me in the code where it says that? I have a copy of the code if you need.
Yeah. This is the decision. Here we are. The requirement of C1 under 150.14 says, describe the special conditions or exceptional circumstances peculiar to the property which would cause the undue hardship or that prevent the applicant from complying with this chapter with on-site or off-site mitigation and any evidence that compliance would result in an environmentally degraded condition on or off-site.
Thank you. So there was nothing in there specifically that it has to be just size, shape, or topography that's considered when it comes to special conditions or peculiar notations?
No.
So could existing structures make a property special or unique?
I don't see how.
Could you explain that for me?
It's not an inherent characteristic of the property itself. It's a structure on the property.
But changing structures, or moving structures, that could be considered, though, an undue hardship, correct?
I think as we've demonstrated, there are a lot of other locations on the site that could accommodate a structure that size. So I don't see why we should be considering moving structures.
Thank you. Which is, I like how you think, a nice transition here. So you had discussed the adjacent properties that were potentially owned by the church or the applicant. Are those properties at issue today or were mentioned in the application, the conservation plan, the variance request at all?
The site that was described was the 25 acres.
Correct. And so are you aware that we at the county, nor any private attorney, nor any government can force any applicant to use any property that is not being applied for in the variance?
That's one of the things about being an assistant of private enterprise.
Thank you. I'm going to jump back a little bit here. So under 150.14, which we just looked at, when it states that the applicant should demonstrate under the criteria, that's 1 through 5, are you aware if any part of the code states how they must demonstrate that things are unique or there is an undue hardship or something's peculiar?
No, but they didn't demonstrate it at all.
But would that not be a subjective opinion that could be held by county staff or by the applicant?
Well, this says demonstrate in sufficient detail. There was no detail.
But sufficient detail would be a subjective standard, correct?
Yeah, but you have to have some details to even approach the term sufficient detail.
Absolutely. And on, when it comes to, I'm looking at now page 2 of what I believe was appellants 4. Would this secondary letter have been submitted simultaneously with the initial variance request, which is page 1?
This letter?
No, the page before it, I believe. Yes, that one.
Would this have been, that was submitted with the application, I believe.
And does it not, at the very end, delineate additional evaluations and considerations, criteria, statements that were submitted with the application?
Yes, but it doesn't give any detail.
Are you aware if there was any conversation between the applicant or the county staff at this time that could have provided additional explanation?
How could I be aware of discussions?
Thank you. No further questions.
Does anyone in the audience have any questions of Ms. Grover's testimony? Mr. Varga? We didn't swear you in, did we?
Sworn in.
I'm not testifying.
He's not.
Okay, just quiet, okay.
He's on behalf of whom?
Who are you speaking on behalf?
Myself.
Well, no, the only reason I asked the question, I thought he worked for the county, based on his shirt. And if I'm mistaken, I'm prepared to be informed. But he's been talking to Mr. Bowman about the application. They have a lawyer here, and the chair instructed me that all of my clients had to speak through me. I said we would respect that rule, and I'm simply asking whether he's a county employee.
And he is, and.
Then I
Ms.
object.
Moore, if you can call him as a witness.
I do not intend to. I have no control if he wants to testify personally as to his own opinions, but if he is to testify as to anything staff-related or his job, then that is correct. He would need to go through us.
Again, I'm not testifying. I'm asking questions on the testimony that's been provided.
I reiterate my concern.
Mr. Vargas, since you are a county employee, those questions should go through the attorney. Board members.
I have a question. Do we know that the plan that is on that easel and the one that we have is the one that the county used to make their decision?
I'd have to defer to Macy Nelson's office because they
Offer to answer that.
plans.
Ask permission to.
May I answer that question?
Yes.
So my understanding is that the plans that we have are the most up-to-date plans. And when I spoke with members of the county, they said that this indicates up-to-date plans, including parts of it that were previously approved. So my understanding is that the portions of the Forest Conservation Plan that are in this up-to-date plan should reflect or be consistent with or are the same plans the county used to determine. If the county used a different plan, I find that personally a little concerning since they say this is the most up-to-date plan, and then therefore that prior approval, if we're now relying on this plan and if in fact that plan is different, then that prior approval would be void. So my understanding is the plans provided here, which were provided by the county through its website, represented as the most up-to-date plans, are the ones that were approved by the county.
Okay. And has it been your experience that if someone applies for a variance and there is a conversation that happens with the county, does it not have to be documented somewhere in writing that there was a conversation that goes with this variance?
Generally, in my experience, applications for variance and approval documents regarding variances would be very specific and would address the legal requirements and demonstrate compliance with every legal requirement.
Sure, but if that didn't happen, if it were like the one we have in front of us and there were conversations that happened pertaining to this application, is it your experience that they should be in writing somewhere and in the file for the application?
Well, absolutely, but based on my experience, it makes me a little nervous that a variance approval would be based on a conversation somewhere, whether or not it was documented. It should be
Thank you.
based on more than that.
Mr. Caldwell?
No questions.
Ms. Eckert? I'm going to get to the 5 trees. Do you refute that the condition that these trees are in?
I have no reason to controvert that. One is dying or dead, and the rest are, they were, I think, fair to good, but somewhere I read that they were fair.
Did you visit the site? I'm sorry. No, you're gonna, okay.
Oh, what I remember is that one was in poor condition, and there were 6 in fair condition.
And do you refute that?
No.
Okay. Any other questions?
You have one more. I'm
Ms.
sorry.
Fordmount?
If you could verify for me, I believe you said in the beginning that the state of Maryland does not differentiate a dead tree from a poor or fair tree. And so their law is a dead tree has to be considered if it's a specimen tree.
I think what we were discussing was that in the state law and in the county law, there was no provision that specifically said that you do not have to file a variance application for a dead tree. Is that what you're referring to?
So
That's what I said before. I was trying to impart. I'm sorry if I wasn't.
That's okay. So the dead tree, let's say you only had one specimen tree on there and it was dead. Would you have to file a variance for that one dead tree
Yes.
to have it removed?
To not file a variance to remove a specimen tree, you'd have to be able to point to an ordinance, be it at the county level or state level, that specifically says you don't have to apply for this one.
Okay.
In this instance, you don't have to put in this variance application.
Okay, thank you.
I have a follow-up to that. So if it's a safety issue, is there a separate mechanism for that?
That's what, I'm not familiar with your procedures in that respect, but it stands to reason that there's an available emergency procedure if there is a safety, if there's a safety concern regarding the tree.
Is this the?
But I'd have to do a little, I'm sorry.
Oh, no, I didn't mean to cut you off. So is this the first case that you've testified to in Carroll County?
Yeah, I believe so.
Okay. And as another follow-up to one of Ms. Fordmount's questions, you just indicated, and maybe I missed that if you have a dead tree, they're characterized or classified as the same as fair or poor? Is that what you indicated?
They can be, it can be indicated that it's a dead tree, but that still doesn't exempt you from, it doesn't take away the fact that it's a specimen tree. So there's a procedure, and to take it down, you gotta go through the procedure. And that's getting a variance from this ordinance.
Or filing some type of, what you think may be an emergency?
Yeah, maybe in the
Provision.
building department or,
No, would that apply to a tree that's in fair condition as well? Or poor?
we didn't find anything in the law that would, oh, you mean if it's a safety hazard?
Correct, yes.
Yeah, I would imagine there's some kind of procedure that could be followed in the county law for emergencies, but I'm just not sure about
So-
the specifics.
Did you actually visit the site and observe the trees, or are you basing it on
Just basing
aerial
it-
imagery and?
Yes, basing it on all the information in the case file and all the information that's available through the county website.
Thank you.
You're welcome.
Any other questions, board members? Ms. Moore, any follow-up?
No rebuttal.
Okay, thank you very much for your testimony.
May I follow up?
Oh, yes, I'm
briefly?
sorry.
That's okay. No worries.
Thanks for interrupting me.
I just have a few brief questions just to make sure we're clarifying some things. So I recall Ms. Moore asking you whether the existence of existing structures on a site would make a property unique. Do you recall that testimony?
Yes.
And in your experience evaluating variances and evaluating criteria similar to or identical to the requirement that special conditions and exceptional circumstances be peculiar to the property. In your experience evaluating that type of requirement, is an applicant allowed to demonstrate uniqueness just because there are existing structures on the site?
Absolutely not, and that's sort of related to financial gain or economics. That shouldn't be a basis for a variance either, and if someone might have to move a structure or build it somewhere else, that wouldn't impact the application.
And so let me just think of an example about why that would be the case. It's true, is it not, that many properties in this area, across the county, across the state, have existing structures. Is that correct?
Yes.
And so allowing an applicant to show uniqueness based on the existing structures would essentially render that requirement meaningless, would it not?
Right. The
And-
uniqueness has to be of the property itself, not of the structures on the property.
And it's part of the reasoning behind that because you want to make sure it's the land itself, it's the application of the law itself, not actions by the applicant or prior owners that have caused the need for the variance, correct?
Yes.
And to that point as well, did you see any evidence in the record, the application or the file that we've reviewed today, any explanation from the applicant about any other elements or features or characteristics of the existing structures that make them unique compared to other existing structures that exist on the vast majority of other properties in the area?
No, there was no evidence of that type in the case file.
So even if that was permitted, which you asserted is not, correct?
Right.
Even if that was permitted, there's absolutely no evidence to demonstrate here that the existing structures on this site are unique or different or peculiar or exceptional compared to any property in the area. Is that correct?
Correct.
And now I want to talk about moving structures and the question about whether moving a structure would cause an undue hardship. Is there, from your review, any indication that the applicant would be required to move existing structures to protect the existing specimen trees on the site?
No, there's no evidence.
Instead, would you agree that the applicant might have to alter its design for proposed structures to keep the specimen trees that are existing on that site? Is that correct?
Exactly.
So no one is asking, are they, the applicant to move the existing structures on the site? Is that correct, from your understanding?
Correct.
Okay. Now, I recall a question Ms. Moore asked you regarding the property owned by the church, and she asked whether the county can force the church to use other property outside the scope of this application. Do you recall that question?
Yes.
Now, did you look at the other property owned by the church to determine that the applicant had to use that property?
No.
Instead, did you use that information as just one consideration to determine whether or not the applicant would experience an undue hardship if it was required to maintain 5 specimen trees?
Right, that was the main goal of that exercise.
So the point is it not, that the applicant is not required to use its other property adjacent to this property, but the applicant could use it to accomplish its goals. Is that correct?
Right, like they could use other portions of the 25-acre site as well.
And to that point, even if you forget about any of the property around the subject property, the applicant has ample space to accommodate the proposed development without impacting the specimen trees that are located on a very small portion of this property. Is that correct?
Yes, that's correct.
Okay, and now I want to touch on board members' Mount. I apologize, my eyesight's not great from far away. Question about having conversations about this application and whether or not they should be in writing. Do you recall that question?
Mm-hmm.
Now, she asked you generally about your experience, but I want to talk specifically about the Carroll County Ordinance, if I might. The Carroll County Ordinance requires the applicant to provide its reasoning in writing. Is that correct?
Yes, and I looked for it and it wasn't there.
And that reasoning in that writing has to be part of their application materials. Is that correct?
It's supposed to be.
And ordinarily, you have to follow what the law requires, correct?
Absolutely.
Now, the last point I want to touch on is the dead trees and the trees in poor condition. First and foremost, did you see any evidence that the applicant went through any other procedure to get approval to remove the dead specimen tree on its property?
No, nothing was in the case file.
And moreover, just because a tree is dead and just because a tree is in poor condition, does that necessarily require a conclusion that that tree is a danger to other people? Could there be a dead tree that's not dangerous to people nearby or structures nearby?
There could be, and arborists are sent out on task to figure this kind of thing out.
And so, is there any evidence that you saw that the applicant provided for either the dead tree or the trees in poor condition that demonstrate that these trees are in fact a danger to other people, other than by stating they're not in the best health?
No, there wasn't any evidence like that in the case file or any of the materials that I reviewed.
And is it fair to say, is it not, that whether or not there is a county level procedure for removing trees that are hazardous to public health, that track might run parallel to the variance request for a Forest Conservation Act? So to put it more clearly, you might be required to get a variance from the Forest Conservation Act and go through that process for removing a hazardous tree. Is that correct?
You might have to.
And again, it's correct, is it not, that the forest conservation regulations in Carroll County do not allow or do not describe a separate process for approving variances for trees that are in poor, dead, fair conditions. Is that correct?
Right, there's nothing in there.
It just says specimen trees. It does not talk about the health of those trees. Is that correct?
Right.
Okay, thank you. That's all the questions I had.
Any follow-ups, Ms. Moore?
No.
Any more questions, board members? Okay, thank you for your testimony.
You're welcome.
It is 20 minutes after 12. We will come back, we'll adjourn and come back at 1:20.
Thank you, sir.
We're going to call the BZA hearing back to order, and Ms. Votal is going to call a couple of witnesses.
Yes, we just have 2 additional witnesses. So first, we'd like to call Ms. Shirley Appleby, please.
Hello.
Ms. Appleby, you can come to the table.
Oh, come to the
Okay, it's been a long time since I gave instructions, but could you please state for the record your name, address, occupation, and spell for the record your last name?
My name is Shirley Ann Appleby, and I live at 2045 Bachman Valley Road in Manchester. I've lived there for over 40 years. And the spelling my last name is Appleby. I am recently retired, but I am still an active CPA. And like I said, I just recently retired.
Okay, thank you.
Thank you, Ms. Appleby. So this is your opportunity to state before the board whether you oppose or support the Forest Conservation Plan and the variance application for the specimen trees. Do you oppose or support those applications?
I oppose the application for the reasons that our lawyer has specified already.
Were there any other reasons you wanted to share today?
Well, there are a number of reasons, but I personally have done a lot of research on this particular project, and I just feel like the entire process has been handled poorly. I do not think that the original zoning board did their proper due diligence.
I'm so sorry, I'm going to have to object. This is outside of the scope of the
I'm
case at
sorry,
hand today.
could you speak up a little bit?
Yeah, I'm going to object. This is outside of the scope of what the appeal is on today.
And I would concur that we need to hold it to the forest conservation issue.
Yeah, and in that line, Ms. Appleby, just if you have any additional comments, just keep it to the Forest Conservation Plan itself and then its approval and the specimen tree variance. If you have any additional comments at all.
Okay, no, not really. I think that Alex did a wonderful job in detailing everything, and Ruth Grover also did an excellent job in just bringing all the pertinent points out. I just hope that you truly look at everything that they've said and with an open mind and give it the due consideration that you should give it. And thank you for your time. Thank you for looking at this for us. We appreciate it.
Thank you.
Okay.
You might have questions, yeah.
Ms. Appleby, you don't get off that easy.
I'm sorry.
Ms. Moore, do you have any questions of Ms. Appleby?
She may actually get off that easy. I have no questions.
Anyone from the audience have any questions? Board members?
I'm just curious where you are compared to the project. Where is your property?
Well, basically, as the crow flies, I'm like 3 doors down. I'm on a little road. Well, it's like the property line for 2239 is next to Butch Glover's house. And then John, who's about to testify next, lives next to Butch, and then I'm the 3rd house in. So, yeah, I'm about 3 doors down as the crow flies, but not numerically as you hit the mailboxes. I mean, there's a lot more mailboxes in between our 2 houses, but just physically, we're pretty close. I can see their property from my backyard. I could see their little, I guess it's called their archive building or something. It's one of their outbuildings that they're using, and the lights are on all the time. I can go out 2 o'clock in the morning to check on the horses, and the lights are on down there. And I can see clearly what, you know.
Okay, thank you.
Okay, thank you.
Any other questions of Ms. Appleby? Okay, now you can leave.
Sorry.
Thank you, Ms.
It's fun.
Appleby.
Listen, I told you that you would understand the process at the end of the day. I try to explain it in the morning, but you don't get it till you've been through it, so thank you.
This is true. Thank you.
Thank you. Next, I'd like to call John Tremoloni, please. Yeah, and can you state for the record your name and address to start?
My name is John Tremoloni, and my address is 2047 Bachman Valley Road, Manchester, Maryland, 21102.
And can you spell for the record your last name, please?
Trimeloni.
Was there anything else the board needed for record
Occupation?
purposes?
Occupation?
Oh, occupation?
I'm retired. I'm a veteran from the Vietnam era, and I'm retired from the government lately. And right now I'm just retired, so I guess does
Congratulations.
that satisfy that?
And how long have you lived at your property?
I don't remember the exact years. I'm terrible. I'm 81 years old, so in my memory, that type of stuff gets with me, but I think it's either from 91 or 2002 that I moved, I think 91. 1991, I think, was when I bought this property. And I am the citizen of standing, quote unquote, that is opposed to this. I strongly oppose this approval of this variance plan today. I have bigger things, but I know we're limited to the variance plan today, but I think it's pretty clear after over 3 hours of understanding what was going on, if anybody's listening, is clearly not meeting any of the rules that are required to approve this variance. So I think it should be denied.
Thank you, Mr. Tremoloni. And I have just 2 more questions. So you gave us our address. How far is that? You gave us your address. How far is that from the subject property?
It's within 1,000 feet, from what I understand is what's required. I forget the exact number of feet, but there's one house between me and the property, and there's my property.
And can you see the subject property from your house?
Yes, I can. In the summertime, there are trees that makes it a little more difficult to see, and other times there's not. Okay, there's a lot that goes on weekends, and the county won't do anything about weekends because they don't work on the weekends.
We're just
have
gonna
to-
keep, we're gonna keep it to just the forest
Well,
conservation
I don't know
plan.
why I need to be able to see I can see the property.
Okay, thank you. That's all the questions I have. Thank you so much. There are gonna be other questions though before you leave, possibly.
No questions.
Board members?
Yes, one.
Go ahead.
Thank you for your service.
Thank you.
Thank you. And that's, what? Yeah, we rest our case.
Can I make a comment? Oh, excuse me. I gotta go through it, right?
Yes. If he represents you, yes.
He answered my question, thank you.
Okay, very good.
So with that, we rest our case. Thank you so much.
Very good. Ms. Moore?
Yes, I would like to call my first witness, Mr. Jonathan Bowman. Long legs, these tables are short. Mr. Bowman, would you please state your name for the record and your current position with the Carroll County government?
Certainly. I'm Jonathan Bowman. I'm the Landscape and Forest Conservation Specialist for Carroll County.
How long have you held this position?
17 years.
Could you briefly describe what you do in relation to both tree variances and forest conservation plans in your job?
Sure. So regarding forest conservation plans, when a development is proposed, I receive those plans. I review them for compliance with the Chapter 150, which we've been discussing. You had a second portion to that question?
Yes, so in relation to tree variances as well.
Sure. So tree variances also are reviewed by myself. They're submitted. I make sure that the submittal materials meet the standard indicated in the code, and then pass those materials on to our director for approval or denial.
So to keep things consistent, we'll try and divide the testimony in the same way that the appellants did, just for all of our sake of mind and keeping things straight. So we'll discuss the forest conservation plan first and then the tree variance second. So as to the forest conservation plan, Mr. Bowman, could you please let us know whether Appellants Exhibit 3, which has been discussed at length today, is the most recent plan currently at hand in this process?
It is not.
When was the most recent forest conservation plan submitted to you?
I received a plan from DRS and Associates on August 27th of 2024.
Thank you. And were the number of discrepancies that were discussed, most notably, are they still discrepancies that exist in the most recent plans?
No.
At this time, we have no other questions about the forest conservation plan. We're opening to doing the cross at this time, or we can finish on the tree variance, however the board would like to handle this.
What do you think, board? You want questions now?
Yeah, sure, that would be consistent.
Yeah, I just want to make sure, even though the testimony was very short, I just want to make sure. Ms. Votal, do you have any questions of his testimony?
I have a few, yes, thank you. Could you remind me, please, when the department approved the forest conservation plan?
Yeah, could I refer to my file here?
Could we get a bit of just clarification? Is that the plan that we're talking about as Appellant's Exhibit 3, or the one we just referenced being the most recent one?
Well, maybe I'll ask a follow-up question. Has the department approved more than one forest conservation plan?
So understand that anytime plans are submitted, there's a process, and there's versions of plans that are amended and changed by the engineer, and they get resubmitted. So, I mean, in this particular case, the forest conservation plan has been resubmitted 9 times. And I approved it twice. There was a July 9th submission, 2024, that I approved on August 6th of 2024. And the most recent submittal and the only other approval was September 12th, 2024. The plan was submitted, and I approved it on September 24th, 2024.
Okay, so when the county first approved the plan, did it have these inconsistencies?
So my approval on August 6th, I did make a comment in my comment letter related to correcting the some notes and the forest conservation worksheet. So, you know, as plans go, and because they're a fluid process, there's occasions where items are essentially minor enough that I kick it to the next submittal to be corrected. And that particular case was what I did there. So I gave it an approval with the understanding that those items be corrected by the next submittal, which they did. So the latest submittal, the September submittal that I've referenced, those items are corrected.
And the September submittal, is that part of the packet that's available on the county website as the most recent plan?
I'm not aware of what's available on the county website.
Okay. And would the board give me one moment to confer with my co-counsel?
Absolutely.
Thank you. Thank you for your allowing of that. Since we spoke to the county multiple times to confirm whether this plan was the most up-to-date plan, and now we're being told for the first time that there was additional submittal September 12th, 2024. I personally downloaded this plan 3 weeks ago. So if the board would be open to it, we would request a 5-minute recess that we would have the opportunity to review this updated plan, because every plan that we've reviewed, every version has had inconsistencies. And if the county is saying that those have all been resolved, I would like the opportunity to see that if that's permitted by this board.
We will grant that. So we'll take a 5-minute, I think 5-minute?
Maybe 10, if that's all right.
We'll take a 5-minute break.
Okay, thank you very much. the department to ensure that we were using the most updated plan. And we are now being told again for the first time that there is a second plan that has been approved that's different from the first plan that was approved. It's different from what the county directed us to online as the most updated plans. And this version is not available online. So we're prepared to cross-examine on this plan because I still believe there are some serious issues with it. But respectively, we request a postponement so we have the opportunity to really evaluate this plan that's been shown to us for the first time, despite us having recently asked the county numerous times for the most updated plan.
We do have rebuttal if available.
Excuse me, I didn't hear what you said.
We do have rebuttal if available to that argument.
Okay.
Mr. Bowman, I'm going to just ask it in the form of question. Were you ever asked for the original forest conservation plans?
I was not.
Did anyone ever ask you for the amended plans?
No.
No further questions.
I personally called the county planning department and I spoke with the planner that was assigned that day. And she is the one who said she checked with the county and the other departments to ensure the online plan was available. We've also submitted PIA requests to the county, which were answered by the county. And I was told unequivocally by the staff person who I spoke with, I don't remember her name off the top of my head. She was a woman. She was very helpful. She told me this was the most updated plan. I did not specifically call Mr. Bowman. I don't know what his phone number is, but I spoke with the staff that was available with a publicly available number to whom I could speak with.
The planning department is not the Bureau of Resource Management. They are two separate departments technically. And additionally, the PIA request was as to the tree variance only. It was not as to the forest conservation plan. We did answer the PIA request that was submitted within the very narrow confines of what was requested in the PIA.
Ms. Votal, what Ms. Moore said, is that consistent with what your request was, your PIA request?
If you just give me one moment, we have
That's
them
fine.
here. Thank you so much. We want to make sure we're being accurate with our answers. So I have a copy of our PIA request, which was submitted Thursday, November 21st, 2024, in which we requested copies of, so we said we had a copy of the applicant's final site development plan, and we request copies of any other documents that the applicant submitted to the county regarding the proposed development at 2239 Bachmans Valley Road subsequent to October 14, 2024. Including but not limited proposed stormwater management plans and the calculations supporting that plan. And in none of the PIA requests, we had several before that as well, none of those included this plan, which Mr. Bowman says was approved. I believe it was September.
Well, it was submitted.
Submitted in August and approved September, I think you said 19th or in September of 2024.
September 24th.
September 24th, sorry.
I'm going to rule on this. I will grant the continuation. I'm assuming that Mr. Dixon is looking at dates. Assuming that's why he ran to the back phone there. We have one case on our docket for the end of February, which is on Tuesday. Ooh. Not here on Tuesday or Wednesday. I think what's best, the secretary says she cannot be here on the last Tuesday or Wednesday of February. I think it would be unfair to this board and to the applicant if we had another board member sit in or we were down to 3. So we may get Ms. Vance to see the availability of dates.
Okay.
I would say that we will not do it within 30 days. So it'll be after 30 days. Would that be okay?
Yeah, I'm good March 1st.
You're good March 1st, okay.
May I make a suggestion, Chairman? We would propose, if the board is amenable, since we're already here, completing the testimony in the case regarding the variance portion of the appeal, and then we could return to exclusively talk about the forest conservation portion, if the board was open to that way of doing things.
So you're willing to go forward with the variance?
Yes, sir. Assuming there's not
No
an
objection.
updated variance application that we're not aware of, like the forest conservation plan.
Okay. Julie?
You wanna tell
Yeah. I don't want our note taker to. I'm getting the secondhand. I know lawyers don't like secondhand information, but we're gonna trust Ms. Fordmount. She, legal counsel says that she does not want to go any further with the case today. He does not want us to go any further with the case today, and we will go ahead and address everything when we meet back again for the continuance.
Thank you so much, board members.
Ms. Moore?
No objection to that.
Okay. So very good. It will be, I can tell you this, it will be in the month of March based on schedules, so, and the availability of this room. So thank you very much for your indulgence here today and your testimony and patience that we've had, and we will see you in the month of March. Thank you very much. This hearing is adjourned.
Thank you so much.